In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the January term AD 2023 of the Criminal District Court of Jefferson County in said county and state, upon oath in said court present that Raymond Peoples, hereafter styled the defendant, on or about this the 6th day of June 2023 and anterior to the presentment of this indictment, in the county of Jefferson and state of Texas, did then and there intentionally, knowingly, or recklessly cause bodily injury to Charles Ford by striking Charles Ford about the head and body with pins, and the defendant did then and there use or exhibit a deadly weapon, to wit pins, that in the manner of its use and intended use is capable of causing serious bodily injury or death during the commission of said assault. And the defendant did then and there know that said Charles Ford was a public servant, to wit, a Jefferson County Corrections Officer in the lawful discharge of an official duty, to wit, transporting said defendant with the correctional facility against the peace and dignity of the state, signed by the foreman of the grand jury.
Raymond Peoples, as defendant in this case, you've heard the indictment read by the state. How do you plead it as, guilty or not guilty?
Not guilty.
Not guilty is entered into the record on your behalf. You may be seated. State may.
Brecken put this together for me, and she trimmed it down quite a bit from there, but I think we have the whole trial.
Make an opening statement at this time if you wish.
Good morning.
I think this is originally Alyssa's fault, and then Brecken did the heavy lifting here.
This is, as far as evidence goes, it's going to be a relatively simple trial. And what I'm going to tell you is not an argument this morning. That'll come later on after the evidence is presented. What I'm going to tell you now is what I expect the evidence to show you, or what I'm going to present. I'll give you a roadmap of what's going on. So back in June of 2023, Raymond Peoples was in what they call isolation cell. And you're going to hear from Lieutenant Charles Ford, who is the complainant in this case, that Raymond Peoples was in that isolation cell because he threw some feces on Lieutenant Ford in the past, and they put him in isolation. And then he kept doing things to stay in isolation, so they kept him in isolation.
I met Brecken one time because I had to go to a wedding in Grand Rapids. Shout out to my nephew, Max. Great kid. Nice wedding. Still wasn't great to see my cool nephew throw his life away, but I got to have breakfast with Brecken.
On that day, on June 6th of 2023, Lieutenant Ford was ordered by his captain to take Raymond Peoples and remove him from cell number 6, isolation cell 6, down to isolation cell 1, so they could do maintenance on cell 6. It was a simple thing. You go down, you tell them, pack up your stuff, move down here to this cell. And
I'm going to another one this week in Georgia.
Everything's good. You're going to hear that Mr. Peoples decided that he's not going to do that he didn't want to move. He claimed that the other cell was full of feces and urine, and that it smelled, and that they were just trying to get him down there to put him in a bad cell. You're going to hear from a couple of the jailers who talk about the fact that cell had just been cleaned. They had cleaned it. It was clean. Matter of fact, you're going to get to see a video of
I bite my tongue at weddings and roll with it. At that point, it's too late. They've already made the decision.
The incidents as they occur. There's no sound, but there's video of Lieutenant Ford, several other officers trying to talk to Mr. People to come out and go down there. You're also going to see one of the officers actually go down to the cell just to show him. He walks down to the cell, and you'll see him stick his head in, and he's in there for a little while looking around, making sure that everything's okay, and comes back. And still Mr. People won't come out. What you're going to notice in the video, if you look real closely, is you're going to notice that when you see it, Lieutenant Ford's going to point out that right when he starts talking to him, you're going to see that he has his hands wrapped up with cloth. And he's ready to fight. And that's always a bad thing with inmates. So they try. You're going to see probably about 4 or 5 officers talk to him in the window and try to cajole him to come out and do it peacefully. and he puts his mattress up against the wall of the cell, the door of the cell. You're going to see that in the video. You're going to see the mattress go up against that little window because there's a camera pointing right towards his cell. It comes up. They still try to talk to him. So they decide to do the next step up. And the next level up is we got these little pepper balls in this little gun. And since he's plugged up his little food tray thing where they also stick their hands out to be cuffed so that they can come out and be transported to another place, they fire 3 or 4 pepper balls sprayed up in the top to kind of try to get him to comply. And still, he doesn't stick his hands out. He doesn't do what he's supposed to do. He still keeps the mattress up against the door. And so now they have to do what they didn't want to do, which is go in and take him by force. So there's 4 or 5 of them that go in, and they all stand around and they open up the door. You'll see him open up the door. You'll see him come out. And in both of his hands, he has his hands wrapped, and he has ballpoint pens, and they're trying to tackle him, and he's trying to swing. And you'll see them actually hit the floor, and they go down and get in a bundle. And while they're down on the floor, you're going to hear one of the Sergeant Anderson. He's going to tell you that Raymond Peoples strikes Lieutenant Ford with the pin in the face and in the neck area. You'll see some blood up here around his up above his eye, some scratches down here. You'll also hear Lieutenant Ford say that while they were down there, that after they got his hands restrained in front, that Raymond Peoples leans up and scratches his whole face, and you'll see the scratches down the side of his face. And you're going to hear all the jailers talk about how they finally got him subdued. They finally get him down to cell number 1 and put him in cell number 1, and he starts fighting again. And so they have to take him and they put him in what's called a wrap. And a wrap is kind of like putting somebody in a burrito wrap. It wraps them up so they can't hurt themselves, can't hurt anybody else. And then they have the nurse check them out, and everything's fine with him. The only one injured out of all this is Lieutenant Ford. You're going to hear all the officers, or most of the officers, say that Mr. Peoples was continually yelling out, "I'm going to kill you, Ford. I'm going to kill you, Ford." That this was a personal thing that he was going to do, and he planned on doing it. You're also going to hear that they used the least amount, and that there were no injuries on Mr. Peoples. When they got him down there, there was not an injury on him. He did not have a bump or bruise or anything, that they used just what they had to get him where they needed to. Then we're going to switch to April of 2026 this year. You're going to hear from Officer Tinker, who has an incident with Mr. Peoples. Mr. Peoples lays on the floor and refuses to move again, and so they're going to have to use force to get him up. And you're going to hear Officer Tinker tell him that he's going to use some language that I'll let Officer Tinker read it out loud to you. But during that conversation, he also tells him, "I've stabbed."
No. And during opening statement, don't interrupt, sir. It's his version of what he expects the jury to show. Don't object. That's not for you to object to. Stay quiet. You get your chance to make an opening statement. Proceed. Thank you. That's the rule of law.
The defendant's going to tell Officer Tinker that I've stabbed supervisors before and I got away with it. I'll get away with it again. You're going to hear all this, and at the end of all this, and once you see the video and you listen to the officers and how this all went down, you're going to see that Raymond Peoples was trying to kill, gouge, hurt, harm, cause bodily injury to Lieutenant Ford, and did so with a pen and also with his hands. I look forward to presenting the case to you.
All right, Mr. Peoples, do you want to make an opening statement at this time?
Yes, I
You
do.
can defer until after the state rests. You want to make it now? Go ahead.
Name is Raymond Peoples, 37 years old. Been incarcerated since 2019 as a completely innocent man on the charges that I was originally brought in here for. And what you're going to find out, this charge right here specifically is merely and completely solely retaliation, especially through conspiracy or whatnot. This charge and the other charge with implements for escape solely is retaliation through conspiracy or whatnot. And you're going to also see it's going to be a lot of stuff that is going to be unbelievable that that I'm doing my testimony that you're going to hear or whatnot. But I won't testify to nothing that I don't have evidence to. Everything is going to be evidentially brought up within paperwork, timing, circumstances. Everything is on record. Anything that I bring up as a defense and justification to anything is on record. Yeah, nothing that I will tell you will be a lie. What you will realize is that the justice system right now or whatnot, outside of the actual criminals or whatnot, there are some people that comes to jail or whatnot that actually is innocent. But there's quite a few people within the justice system with power that don't care at all about innocence, period. All they want is convictions. And the fact that a lot of you have have family or whatnot that works within the legal system, I'm pretty sure you were aware that mistakes does happen with people that, you know what I'm saying, actually get charged. Innocent people get charged with crimes that they didn't commit. And even Mr. Stevens had to apologize months ago to a man that spent 18 years in prison and convicted in this county as an innocent man.
Hold on. That's outside the evidence, and that is a complete misstatement, sir. You deal with the evidence on this case.
Okay. So
Please, sir,
yes, yes, sir. Yes, Your Honor.
keeping in mind, this court received the Attorney General Award, the highest award given by the United States government by President Clinton for my prosecution of the James Byrd murders. So don't be alleging that I'm doing anything inappropriate, sir. Stay with the facts of this case. Move forward on the facts of this case. Let the jury understand what this case is about and make a ruling on this case and the facts here. Go ahead.
So talking about facts, there was 6 officers that was present that day, right? The guy that he mentioned, Lieutenant Tinker, he was nowhere around that day. Matter of fact, he wasn't even working that day. So for him to be coming to testify, he has nothing to do with this case. That's why I was trying to object, because there's going to be situations that I need to bring up, you know what I'm saying, that correlates with this situation, but he's going to tell me it don't have nothing to do with the case. But yet he's allowing the district attorney to bring up situations that has nothing, absolutely nothing.
Once again, sir, do not talk about what the evidence in this case is, sir.
That's what the evidence. Retaliation through
What the
conspiracy.
evidence that
Retaliation
happened on
through
this
conspiracy.
occasion on or about June 6th, 2023 in Jefferson County, Texas.
Right.
That's what this is about.
Right.
This isn't a sermon from you on what you don't like and what you like.
No.
Please stay with the facts. Thank you for
Right.
following the rules.
So that's why I'm explaining this to them, because it correlates with retaliation through conspiracy, right? You know, I'm tired of this back and forth. I'm done. I'm just talk to y'all from the testimony.
All right, the statement, call your first witness.
Lieutenant Charles Ford.
Come forward, sir.
This is giving me Daryl Brooks vibes. Just a guy who's absolutely mentally deficient, taking on his own defense.
Please raise your right hand. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please have a seat. Thank you. You'd be so kind, keep that microphone close to your voice. It's what they call a directional microphone, which means you have to speak right into it.
Yes, sir.
Thank you. Go ahead.
Can you state your name, please?
Charles Ford,
And where do you work?
Jefferson County Sheriff's Office,
How long have you worked for them?
24 years.
And what do you do for them?
I'm a lieutenant in correction.
Back on April 6th of 2023, were you a lieutenant with corrections?
Yes, sir.
And what were you, as a lieutenant, what are your duties? Part of
Supervising operations of the unit, inmates, supervision, making sure the officers are doing what they're supposed to do. And then make sure all the inmates are getting everything that they're allowed to by law.
okay. You know an inmate by the name of Raymond Peoples,
I do.
and you seen him in the courtroom today.
Yes, I do.
And you point to him and describe something he's wearing.
The, solid black shirt and all
Let the reflexes identify the defendant.
Yes, it will.
And how do you know Raymond Peoples?
that. He's currently incarcerated in our facility.
How long's he been in there?
Exact time, I don't know. I know since at least 2022 for sure.
Has he been there off and on?
Yes, sir.
And was he always where he was when this happened, June 6th of 2023? Was he in an isolated cell?
No,
Where was he originally placed when he first got to it?
he was in maximum security, in an open cell that was among the rest of the other inmates within that dorm building.
Okay. And those settings are, you say dormitory or cell, which one?
Well, it's a dorm that has, single cells all the way around that have open bars and, they can communicate from side to side and, they're pretty area.
So when was he moved to an isolated cell? You remember?
October of 2022.
So when he got there, it was in 2022. And so in October 2022, he moved to an isolated cell. What for?
Initial, he was throwing feces on a trustee that was in the dorm. And then we tried to approach him later on the situation and he threw liquid feces on me and the other officer that was there.
What happens when people do that? What does that do to them in a jail situation?
It puts them in a situation where they will be isolated and isolated.
Okay, well, let's talk about an isolation cell. What are isolation cells?
It's a solid cell, solid front door with a food court on it that has to be opened with a key. Solid brick walls all the way around, less communication between other people.
And when people are in there, do they stay in there their whole stay, or can they work their way out?
They can work their way,
How can they do that?
adjusting their behavior, making, following the rules, not, committing violations within the jail, not assaulting staff members. So, and such.
So did Raymond Peoples ever work his way out of an isolation cell?
No, sir.
But tell me what kind of inmate is Raymond Peoples to deal with on a day-to-day basis?
Difficult.
What does he do to make life difficult or make it difficult to take care of?
Everything in the jail is built against him. It's done to, intentionally harm him or, prevent him from getting whatever he's supposed to get in some sort of way.
Is he getting everything everybody else gets according to law?
Yes, sir.
Has he gotten any special favors from anybody just to make sure that he goes on board to take care of what he needs? Just what he needs, am I right? Is that your job, is to make sure people get what they need?
Yes, sir.
Is he also protected by certain things, by certain rights in that jail cell?
Mhm.
Yes,
Yes.
I'm sorry, she has to type it.
I'm sorry.
And in that single cell, what is he allowed to have?
His property, personal property, hygiene, legal work, everything that every other inmate is allowed to have, as far as personal property and, his day-to-day, need.
Now, has he had some kind of personal fixation on you personally trying to
I believe so.
harm his rights? And did it all start back with that feces throwing thing?
I believe so.
And with the feces throwing, what was there, did he make any accusations whenever y'all moved him to a single cell back then?
He accused me of stealing his property and not returning it to me. During the incident, his property was packed and the cell was clean. The whole area had to be clean. Cells next to him had to be clean. In front of the cell, the day room, all that had to be clean. And everything was removed from his cell and cleaned up and He was placed in a single cell,
Okay.
or an isolation cell. So,
So it sounds like it was scattered pretty, must have been a big mess when you
Yes,
was
sir.
throwing that. So did you pack up his cell and take everything over there?
I didn't know.
Okay.
I tended to get him secured in an isolation cell, and I went to go clean up.
So how many people are along the isolation cell?
There's nothing like a throuple coming.
In that particular area as well.
Are they always full or just sometimes there's some, sometimes there's not?
I usually would tell the door.
Well, on June 6th of, right, June 6th of 2023. What cell was Raymond Peoples in?
Nora Isolation 6.
Okay. Nora, do y'all have like letters for certain parts of the?
Yeah, on the door it says NI-06 on it.
So the N Nora isolation 06 is the
Yes,
cell.
sir.
And that day, was there something that required Raymond Peoples to have to move from isolation cells?
Yes, sir. My captain instructed us that cell needed to be decommissioned temporarily for security purposes to improve the cell. And he would have to be removed from the cell and put in a different cell that we had available.
Now y'all have certain jail standards that you're required to follow, don't you?
Yes, sir.
And sometimes they update it and certain things have to be done to your cells.
Yes, sir.
So that day when y'all had to move him for the maintenance to get that done, where were you going to move them to?
Two isolation cells on.
So 5 cells down.
Yes, sir.
Now isolation cell 1, was there anybody in isolation cell 1 at that time?
Not at that time.
Whenever you remove somebody from an isolation cell, do trustees go in or does anybody go in and clean those up?
Yes, sir.
And those trustees, when they clean, are they inspected afterwards to make sure they've done what they're supposed to do?
Yes, sir.
So was isolation cell 1 clean that before y'all were going to move Raymond Peoples down to isolation cell?
Yes, sir.
Matter of fact, during the process of talking to him, did somebody go down and check isolation cell 1 to make sure it'd be clean?
Yes, sir.
So let's talk about that day. Who was it that approached Raymond Peoples to tell him we got to move you from isolation cell 6 to isolation cell 1?
I believe it was good.
And when you did that, how receptive was Raymond Peoples to your wanting to move? No.
Not receptive at all.
Was there anything that led you to believe that it might be a problem moving him? What was that?
He straight up told us that there was going to be a fight. He didn't want to move, and we were out to get him.
Did he have anything that showed you that he was serious about it was going to be a fight?
Yes, he had his hands wrapped up with 2 8 pins. Kind of sticking out the bottom as if you could use it as a weapon.
Okay. Now, the wrap, what was the wrap? Could you tell what they
I
were?
couldn't tell what it was. I could tell it was a white ball.
Okay. Just white cloth on both hands?
Yes, sir.
And you could see the ink pens.
Mhm.
What kind of ink pens were they?
Just regular little thick plastic pins. They're dark gray. They're transparent. You can see through them so that they can, see if they can hide anything in.
Kind of good?
Exactly like that.
So when you see that, what do you got to do now?
Get prepared to extract him from the cell safely.
Whenever you get a situation like that and somebody's ready to fight, do you just go in, rush in and go grab them out, drag them
No,
out?
sir. So we try to talk them down, spend some time together, try to de-escalate the situation to see if, we can resolve this without any force and, just try to do it peacefully.
So did you come back? Did you have another officer with you that tried to talk to Mr. People?
I do.
And who was that?
Officer Senegal.
Okay. Why'd you bring Officer Senegar?
Senegar is very good at talking with people. He has a way of talking people down. He's a very people person.
Was he able to talk?
Not that good.
Okay. So did you bring anybody else in to talk to Mr. People?
I brought several other people to talk with him. Officer Darby showed up to help. Officer Jay Stevens showed up to help. And, after, trying to de-escalate it, there was no talking them down.
Was there a sign that you knew that it was the communications were over? Did he do something in the cell to kind of shut it off?
He took his mattress and covered up his food port, which the mattress is about 2.5 foot wide, by about 6 foot long, and it was pressed up against the door so that when the food port would be open, there was no access to the cell. If we needed to spray some chemical agents or something like that, it wasn't going to go in the cell.
That food port, what is that you use for mostly?
It's used for serving chow. We lay, give it to them. That's where their food tray goes in, and if they're removed from the cell for any reason, they're restrained by the wrist before they come with the answer.
Okay, because they've proven to be a problem. Is that why you cuff them before you bring them out?
That is our general policy on anybody that's removed out of any cell in maximum security.
So it's not anything new to anybody. It wasn't just particularly for him.
No.
So anybody before they're removed out of the cell has to be restrained.
Restrained by the wrist, yes, sir.
That for everybody's sake.
Yes, sir.
So you go to the cell, you try talking to him, he's not coming out. What's your next step that you've got to do?
I went and retrieved what we call the pepper ball launcher. It's a device which shoots pepper balls that are about the size of paintballs that have powdered chemical agent in it, which is basically powdered pepper spray. The cell door was opened. A couple rounds were fired off into the cell, not directly at him, but above his head, so that the powder could take effect, and that didn't work. Once they were shot, the door was immediately closed, and we waited a little bit, and it wasn't a thing.
Pretty strong stuff, isn't it?
It is.
I mean,
It shut me up quite a bit.
can you see y'all on the video? Can you see y'all kind of walking away,
Yes.
trying to get away from it? And yet that still didn't work.
No.
So what do you got to do next?
Forcibly removed him from the cell.
Now, is that something y'all like to do?
No.
Why is it you don't like to do that?
The minute the door opens without someone restrained and force is imminent to be used, there's a possibility of injuries, of staff, of the inmate, of anybody that could be involved in the situation. And our goal at the end of the day is to walk out the same way we came.
And also have your inmates not get hurt if they don't have to. Is that right?
Yes.
So let me ask you this: when you do that, do you just go in with one or two, or do you go in with plenty of force?
As many as I can.
Okay. Why is that?
It's easier to control someone when there's more hands involved. More people can, I can have one person on one arm, one person on another, same with the legs, and, minimize their movements and lessen the risk of somebody getting hurt.
So when we start back at the beginning of this, if he had said, yes, I'll move down to the other cell, would any of this been necessary?
Not at all.
Now, does it ever look pretty whenever you go use force on an individual?
No.
And if it's at all avoidable, y'all do that, am I right?
Yes, sir.
So you had to open the door and go in, am I right?
Yes, sir.
So going in, you don't actually go in the cell, do you?
No. Once the cell door was opened, he had his mattress and came out of the cell, or tried to come out of the cell, and the mattress was removed and he was taken to the floor.
Okay. What did he have in his hands when he came out the door?
He had the pins wrapped up in the.
You remember him trying to swing those pins?
Once he came out and was taken to the floor, there was an incident where he broke loose of the officer's grasp and he charged directly at me with those in his hand.
Okay. And that's why you're all down on the ground, kind of.
Yes, sir.
Okay. Now you've got all this going on with him. You've got other officers. Everybody's trying to grab different parts. Is there a lot of moving parts going on in there?
Very much so.
Okay. So while you're doing this, what were you concentrating on your part and they're concentrating on their part? What was going on?
The concentration was trying to get him restrained, because at that point, I don't believe he was, restrained at that point.
So then y'all got him on the ground. You're close quarters with him at that point, aren't you?
Yes.
I mean, y'all are all right there on top of him, trying to get him to do stuff. Am I right?
Mhm.
Yes.
Yes.
So was there a part where you felt pain while he was doing all this?
When he charged at me, yes, sir, I felt pain to my face and chest. And side of my head.
Now, in your report, I think you said he grabbed you by the head and scratched you on the side. Is that right?
I believe so. I remember him coming at me, and I remember feeling sharp pain in my face and side of the area.
Okay. So you don't know if it was from the pins and scratches or all of the above.
Yeah, all it could have been all of it.
Was he saying anything while he's doing all this?
At one point, he did mention that he wanted to kill me.
Was he trying to say that about anybody else or just you?
I just heard my name.
Okay. Did y'all finally get his hands restrained?
Yes,
That take a little bit.
it took a while. Yes, sir.
Now I know whenever you look back and see it, did you watch the video? We're going to show the video in a minute. Did you watch the video this morning? It just took a little while, didn't it?
Yes, sir.
Does it seem a little longer when you're in there in the tussle?
Well, the video actually makes it feel longer than it felt like it happened so quickly.
Everything just,
Yeah.
so when you got up and y'all got him restrained, was the fight over then?
No, sir.
What happened after you got him up?
We got him up, walked him to the cell, and we went into the cell. And he still was threatening to kill me, and there was he wasn't calming down at all. And so we felt that if we tried unrestraining him, there's gonna be some more violence.
So what did you decide to do?
We put him in what's called a wrap. It's a restraint system that minimizes the movements of their arms, their legs, and their entire body. And it just that there's no movement once you're in that system.
To do that, did you do it in the cell or did you take him somewhere?
No, he was walked to the day room that was around the corner and placed in the restraint system there. And then once he was restrained, and that we called the nurse to check to see if he had full, if he had what we call circulation on his extremities.
So when you put the wrap on him, if you tighten it too much, it might cut some circulation off.
Yes, sir.
So you have the nurse check him, make sure he's okay.
Yes, sir.
And was he clear?
He was good.
How long do they stay in the wrap?
2 hours.
And then once they're released, back to normal, where they go?
If we have to let them up for, range of motion and everything, and if they're still showing violent behavior, they go back in.
Okay. So do you remember, did he show anything after that, after the wrap, did that calm him down?
I don't recall. I believe I was cleaning up.
Okay, you weren't around, okay. So the video we talked about, there's several videos. There's one of the incident, is that correct?
Mhm.
Yes?
Yes, sir.
Is there one of, 3 of them of walking him down to where you put the wrap on?
There's video from where the incident happened all the way to where he was placed in the wrap, and the videos depict all of the paths we took.
Okay. So State's Exhibit 1, that what you watched this morning, and do all those videos fairly and accurately depict what happened that day on June 6, 2023?
Yes, sir.
Tender States 1, the videos.
No.
Without objection, it is admitted.
Permission public.
That is granted.
You can step up and just kind of point to where his cell is, so we'll know what we're talking about.
Right here is his cell.
That's cell number 6, and where were you trying to move him to?
Down here to cell 1 where this door is open.
Okay. Thanks, sir. So who is the coming through the door or the gate there or the elbow?
That's Officer Senegal.
This is Officer Senegal right here.
Yes, sir.
Who's this right here?
That's me.
Okay. What can you see through those windows of the doorway right now, it tells you there might be a problem.
I can see his, wrists wrapped up. I can see his wrist wrapped up in his hand.
You can see the white wrapped around his hand.
Yes, sir, with the pin.
Does it appear that you're trying to talk him out, coming out?
Yes, sir.
Is this where Officer Syndergaard kind of taking over the conversation?
Yes, sir.
What is this female officer doing, Taylor doing right here?
Initially, she had taken the paper off of his cell to move it to cell 1, because that's where he was gonna be housed. And now she's, doing what's called observation sheets, where we look in the cell, see what they're doing, right there, lie on the right side. It's basically an observation of what we see.
How often do y'all do that?
It looked at every, less than 30 minutes.
Okay.
No less than 30.
So at this point, has Officer Syndergaard been successful?
No, sir.
Where did that door lead to you're going through?
The one at the top of the screen?
Yeah.
That goes to the main entrance of the dormitory.
Okay. Who's this officer?
Officer Darwin.
And see also talking to random people.
Yes, sir.
And who's this officer?
Officer J. Steven.
And now is Officer Stevens trying to be involved.
Yes, sir.
Where's Officer Darby going?
I'm not sure.
Is he down there in cell number 1 up here?
Oh, yes, yeah.
Let's go back. So he goes down and looks in cell number 1, right? Back you up a little bit. That's cell number 1, isn't it?
Yes, sir. Yes, sir.
What do you got here?
That's, the pepper ball officer.
Did he just put something up against the door?
Yes, sir.
What did he put?
His mattress. It's blocking the window and the food court.
You can see the mattress, can't you, when that door open?
Yes, sir.
And so you can see some light movement through here after the purple ball went in, can't you? So a little bit.
Yes, sir.
But it doesn't get removed. The mattress still stays there, doesn't it?
Yes, sir.
All right. And what happens now if he won't come out now?
We have to open the door and remove him from the cell without restraints and a completely unknown as to what's gonna happen once the door opens.
That's where the trouble always happens, isn't it?
Yes, sir.
Officer Darby has his handcuffs out. Does it look like he's fixing to comply? Or is he just? I'll ask him.
I think it's hopeful.
Who's this? Just walk to me.
That's Sergeant Anderson.
And somewhere in this file, is that where you got injured?
Yes, sir.
He's fighting again.
Is that a question?
Is he fighting again?
Yes.
Where are y'all taking him to right now?
The isolation cell 1.
While you were in there, did you notice any feces on the wall or urine smell or anything like that?
No, sir.
Once again, would this have ended everything if it had just calmed down right there?
One more time, sir?
I said, would this have ended everything if it had just calmed down right there and just stayed in that cell?
Yes, sir.
Is that what happened?
No, sir.
Now, what do you do with the defendant?
He's being removed from the cell so that he can be brought to another area and placed in the rack.
And is that because of how he was acting in isolation cell number 1?
Yes, sir.
What is this?
This is the area that, where it says N100, that is the main entrance. The door that's open to the bottom of the screen on the left, that is going to the main area of the dormitory with the day room that he was going to be training.
So when you're bringing him, are you bringing him from this N101?
There
Yes,
she
sir,
is.
that's the isolation hall.
Okay. Is that you?
Yes, sir.
And on your head, you see blood on your head.
Yes,
So
sir.
that. Is there blood right here above your eye?
Yes, sir.
And after taking you through this door, wherever y'all going?
Down where the little yellow lines lead to the other side of the wall on the left, there's a day room.
Where's this?
This is the entrance to the door. The door we just walked through is just behind the camera.
So you're looking from that door for the day room.
Yes, sir.
Is that y'all escorting with the people to the day room?
Yes, sir.
What is this?
That is the day room itself.
So where's that hallway door that you're coming through?
Bottom left one.
And is this y'all escorting Mr. Peoples into the day room?
Yes, sir.
Is that gonna cause a problem again?
I don't know where Alyssa is. They might have thrown her in the Tower of London.
I need to back it up.
I believe he was being a little resistant to getting restrained.
Is this the way you want your days to go when you're on duty?
Absolutely not.
Could this all have been avoided by Mr. Peoples just saying, yes, I'll move to the other cell?
Absolutely.
What is that?
That is the cart that's used to transport the inmate while they're in the RAP system.
And where does he spend his 2 hours when he's in the RAP?
In the shower area, right behind that. There's a wall right behind where all the officers are standing, and
I warned her they don't like it when you speak English in London. I told her to pick up a few Arabic phrases, but no.
there's a doorway that goes in with
She went
the shower
without-
area.
Is there somebody there that
Not even
watches him?
trying.
Yes, sir.
Do they stay with him the whole 2 hours?
Yes, sir.
So that's him going through the door now.
Yes, sir.
And is that where the nurse will examine? Good.
Yes, sir.
I want to go back real quick to the original one. Let's see if we can. What is this right here in his hand?
Up here.
Is that how he had both the pins in his hands?
Yes, sir.
You would think you could speak English in England, and you'd be wrong.
Who's coming out? When people come out with those, what can happen with those pins?
If he uses a weapon, he can be stabbed.
So this is how he was inside the cell too. Does he have? It's kind of hard to tell with this. Does he have the wraps around his hands? Can you see those two?
I can't see it in this video, but when he was walking to the cell, he did have them wrapped around.
Like that right
Yeah,
there.
right there.
So you can see the wraps around his hands where he had the pins wrapped in his hands. Am I right?
Yes, sir.
Hey, Fletcher
Let me
boy.
show you some exhibits. Let's just go ahead and do all of this. These states exhibits 2 through 33. Did you look at those in my office this morning and do you recognize them?
Yes, sir.
Do they fairly and accurately depict the cell, the injuries you sustained, and some of the items laying on the floor outside the jail cell on
Yes.
June 6, 2023?
Yes, sir.
Those fairly and accurately depict the cell that you took him out of, the injuries that you sustained, and a picture of Mr. Peoples.
Yes, sir.
Interstates 2 through 33.
This is all supposed to be cell 6, right?
Yes.
Yes.
Okay. No objection.
All right, states exhibits 2 through 33 are admitted.
Got out of order, so we're taking a bit of time. So states exhibit number, let me get this up. States exhibit number 2. What is that a picture of?
That is the inside of the cell from the doorway.
Now, it's kind of hard. Oh, Lightening it or darkening, you'll help it. It's kind of hard to see, but is there a toilet back here in the back right here?
Back left, yes, sir.
And what is this right here?
It's a shower.
And this? Well, can't do that. Don't do that. That shuts my light off completely. Go turn the light back on. Please. Thank you. Okay.
Can you is she able to dim them a little and still?
I'll tell you what, let's try, turn it off and I'll turn the light on this and we'll see if that helps. That might be better. We'll leave it like that.
Thank you.
I got all kinds of stuff. So this is the toilet, is that correct?
Yes,
And this is the table you said,
yes, sir.
and is that the shower?
Yes.
And what is this over here?
That is the bunk in which they lay on.
That's exhibit 3, that just a longer view of it, the whole cell.
Yes.
And states exhibit 4, what is this?
That's the observation tag that we use to, when we make rounds, we have a device that logs when we tap that as to the fact that we verified the inmate round
Okay.
and observed the inmate.
States exhibit 6, what is this?
That is the isolation hallway, right before his cell,
What is this right here?
his cell door.
Okay. And this little slot right here, what is it?
That's the food port.
Okay, that's the port you're talking about with, yeah, is it used to put food trays through?
To put food trays through and for them to put their arms through to be restrained so we can open the door and move them about the facility.
States exhibit 5, what are we looking at here?
That's what was removed from him in his cell. After we extracted him. Dead linens.
Some of these pictures got out of order, so we're gonna do them a little bit better here. States exhibit 22, what is that?
That is the short hallway going before we enter the, day room.
Is this the door that Mr. Peoples was in cell 6?
No,
That's not it?
no, that's the storage room door.
Okay. So this is storage right here?
Yes,
Okay.
next to it is an office.
Okay. 23. We took a picture of everything, so doing. That's, what is that?
Should be the inside of cell, ISO 6.
Is that the toilet?
Yes, sir.
Okay. Page 24,
Sink of ISO 6.
looks like it's got some mail attached in it. Mr. Peoples, what it look like?
Yes, sir.
$25,
The inside of the cell.
26,
It appears to be his property bagged up in a mattress cover.
somebody bags it up, moves it down to his other cell.
Yes,
27,
that's underneath the bunk.
28,
Storage box underneath his bunk,
29,
bag of coffee,
30,
the top of his table.
and this is a repeat 31. That's the same bag, isn't it?
Yes, sir.
Okay. And 32 is a little different view, but same bag, right?
Yes, sir.
Okay. Then 33, what we got?
Full view of the inside of the cell.
Okay. Now, after he was placed in the wrap, were there photographs taken to, one of them's kind of blurry, a couple of them are, were the photographs tried to be taken of him to show no injury?
Yes,
So states exhibit 7? Is that Mr. Peoples?
yes, it is.
Is he, what's he in?
He is restrained in the wrap system and also he's still in the cart used to transport.
Same thing with states 9. Got him, is he moving his head and
More than likely is why the picture is blurry.
states exhibit 8, what do we have here?
Him restrained in the wrap.
Now, I noticed whenever y'all were doing all this, did you see a single officer throw any punch?
No.
Did you see a single officer throw any kick towards him?
No,
Did you see any officer knee him?
no.
Was it just being restrained?
It was mainly to get him on the floor and restrained. It was,
And did you see and do you see any injuries, any bruises, any cuts or scrapes on Mr. People?
I do not.
Page 10, who are we looking at here?
That is me.
Now, is this after they cleaned off everything?
Yes, sir.
Page 11, what are we looking at?
the right side of my face.
Now you've got a scratch down here, is that right?
Yes, sir.
And I don't think you can, let's see if I can. Calm this down a little bit. You've got one right above your eye, is that right?
Yes, sir.
Was it also down your nose or was it just on your eye? And then
It started on, above my eyebrow and then skipped my eye and went below. Below my eye,
Basic Exhibit 12. What are we looking at here?
my neck.
Do you have injuries on your neck?
I did, the scratch mark,
Page 13.
scratch marks to my chest.
Now, these look like two different kinds, don't they?
They
Is that-
could be,
That look like a more broad and this looks like a more narrow type.
Yes, sir.
Page 14. That just a different view of those same injuries?
it's a, yeah, part of the back.
So let me ask you the important question. Did those injuries cause you any kind of pain?
They did.
And before I forget, I know this is a silly question, but I have to prove it. Did all of this, even though it occurred at the Jefferson County Jail, did all this occur in Jefferson County, Texas?
They're in Jefferson County, Texas, yes, sir.
Okay. That's exhibit 15. What are we looking at here?
Frontal view of my face with blood on
Was this before you were cleaned off?
it. Yes.
16 looks like a big, let's do 17. What are we looking at here?
The left side of my face.
Was there anything on the left side of your face that caused any injuries?
No, it doesn't appear to be.
Just on the right side?
Right
Okay. Page 18,
side.
is that the right side before it was cleaned off? Does it look like the blood's still coming down your
A
forehead?
little bit, yes, sir.
Okay. Now you saw the pins in his hands, and Mark, you can turn it back on, thank you. You see the pins in his hands when he came out?
Mhm.
You saw him before he came out, is that right?
Yes.
So did you personally see him hit you with the pins themselves?
No.
What did you see?
I've seen an individual coming towards me and hands going towards my face. The pins were still in his hand, but I just saw hands coming towards my face and I tried to get him on the ground.
Did you even feel any of the injuries until after you got back up?
I did. I felt something on my face. I wasn't exactly sure what it was. And then after we started, getting him, the situation started calming down, I felt the burning and, you know, I could feel the blood running down my face.
And at this time that this happened, I have to ask this too, were you a correctional officer working for the Jefferson County Sheriff's Office?
I was.
I'll pass with you.
Before I go before I go through our history, you said I lunged at you with the pins in my hand, correct?
Yes.
Can you please, you're ready to zoom with something, because right before the first time, they took me down to the ground. You say, when y'all first took me down, that's when I got the swinging and stabbing with the pin.
No.
Oh, so the second time you took, that's when I lunged at you with the pin. So your injuries came from the second time or the first time?
Second.
Second. I would like to know, earlier during your testimony, you said, oh, you go right to the part. Yeah. You said this part is when you got injured when I stabbed you. Do you remember that? This part. No, so not the second part, but this part.
No, it was, it was while you were on the ground.
The first
Came
time,
up.
first time or the second time?
It wasn't the first time. It was either this time or when you struggled with us the second time or the third time.
Okay, I'm kind of confused. You said either or. Do you remember or you forgot? Okay. All right, so let's say it was this time for the sake of argument. Let's say it was this time. Right? Now, there's like 6 hands on me right now. 3 faces in my perimeter, right? I'm getting choked at the same time, so I'm almost incapacitated, too incapacitated to.
Your Honor, I'm
Sustained.
testimony.
I'm
Just ask the
asking-
question.
Well, okay,
You're going to get a fair opportunity to testify
Okay,
with that
right,
chance.
right.
Hold on.
Well, let me.
No, when
me
I
ask you-
speak, I instruct the jury that the objection is sustained. In your questions, ask a question. Don't testify. You'll be able to have a chance to testify later. Because right now, anything you say as a question is not evidence. It's the answers under oath. You're not under oath, and that's what constitutes what you're asking is just giving the jury a context so that they can understand why the answer is being made. But your questions are not evidence. Ask them in a question form. You'll have a chance to give your side if you wish later in testimony. Thank you. Go ahead.
Excuse that. So during that time, and y'all had me down, there was a lot of faces. From your perspective, do you believe that there might have been? That's not what happened.
Not right now.
You just got up from, but in the midst of when y'all was trying to restrain, right?
Mhm.
Do you, from your perspective, do you feel like there was just too many hands on me for me to swing at that moment?
No.
It wasn't, okay. So, can you zoom in pardon? Mike, you spell it? We're zooming into this face. As we look at this, can you tell whether or not it's any injuries on your face at that moment?
I can't tell at this moment.
You can't tell. Right there. Do you see any injuries?
I can't tell.
I can't tell. Okay. So can you go ahead and play? With the zoom up? Yeah, with it just like that. So at this part. At that part. Is that when y'all took the pins out of my hands? Or was it after the second time?
Should have been right then.
Right there. This is when y'all took the pins out of my hands. Yeah. So, well, like, no. The first time.
I believe one was removed.
This will be the second time, correct?
That was when you scratched.
Right there. So. Is that the point I lunged at you?
Yes, sir.
Now you say that was when I scratched you. So did I stab you after I scratched you or before I scratched
I know for a fact you scratched me.
you? You feel blood on your head right there?
I can't see the video very well.
After this point, after I scratched you, did we have any more combative encounters after this? The second part?
Walking to the cell, we struggled, and then went in the cell.
You're talking. Wow.
Hold on. Let him complete his answer. Don't speak over his answer, please. Thank you.
You read.
Go ahead. Rephrase. Thank you.
You read. So if me and you physically have any combative confrontation to where you got
You and I know.
to huh?
You and I know.
Yeah, no, so that was it. Okay. Here's my case. You can,
You're passing the witness?
no, I'll rest my case with the video. I was needing them to put what you call it.
That's not the right terminology, but you're going to go to something else. You're gonna ask something else?
Yeah, I'm gonna ask something.
Okay, when you say you rest your case, you sit down and the other side gets,
Okay, I apologize. Let me reiterate. Can you please, turn the projector on?
thank you, Mr. Larry.
Second
Hold on.
page.
You're gonna approach the witness, ask the court to do that, then I'll grant it, but you have to ask. You want to approach the witness for something? You may, go ahead, sir. Thank you.
It's the second page of your report.
You know what?
Well, it's,
I sure love those muffin tops.
and tender, like the tender, enter exhibit, as an exhibit.
You have to move for the admission of it, first show the other side. It just doesn't go in without the other side having a chance to review it. You're asking to admit it and not enter it. I will allow the entry. That's what the court does. You ask for the admission, then he gets a chance to review it and make any, you may ask a witness some question for clarification. Then the court
He understood. He is understanding exactly zero of this conversation.
will make its ruling after the other side has a chance to review it.
Judge, just for record purposes, only mark the states, our defendant's exhibit one.
All That item has been marked Defendant's Exhibit 1. Any objection?
The only objection I have, Judge, is he has parts of this underlined, but I'll let that.
So, no objection?
No.
So Defendant's Exhibit 1 admitted.
So these might have to underline. Is, so I can ask. When you read this report or whatnot, right? Is there anything?
How dare
feel
you?
like you left out of your report that you might have forgot, or
I mean, you might be right.
do you feel like this is accurate when you wrote?
I believe it's accurate.
Yes.
Debbie Davis.
Do you believe
Hola.
it's consistent with what actually happened on the video that you just sent?
Pretty consistent.
Yes. So are we both in agreement that I did not lunge at you with the pins in my hand?
You exited the cell with the pins in your hand as if you were going to be violent towards someone.
Right? Did I lunge at you with the pins in my hand?
Not at that point, no.
Oh, at some point I did? Well, I mean, is that what your report say?
That's actually true, Andrea.
Yeah.
Good point.
Can you read it out, sir?
During the extraction of the cell. During the extraction, he was wielding an pin in each hand in a manner in which he planned to use them to stab someone. Once he was on the floor, it took a few minutes to get his hands restrained due to this combative behavior.
Well, you know,
Next time.
you got your hands full over there. I get it.
After being restrained, he lunged in my direction and grabbed my face, and I felt pain from the top of my forehead to under my neck. As we continued to gain control of him, I instructed officers to move him to NIO 1, which is where he was going to be housed. While in that cell, he continued to fight the threatened officer's arm and threatened to kill me several times. It seemed that he was not going to calm down, so I ordered him to be placed in the rack to minimize his movements and protect himself and any staff members from any further harm.
That's enough. So let me ask you this. Would it be any reason y'all would leave the ink pens in my hand after restraining?
No,
So
you weren't restrained at that particular time. You kept your hands up underneath your chest, preventing us from restraining you.
that would be contradictory to your statement, wouldn't it?
When she taught her, he would You change that. That's,
Ask your next question.
I thought you were about to say something else. So even though your report saying after being restrained, I lunged in your direction, even though your report saying during my restraint, during the time you were restraining me, you didn't take the pins out my hand?
I personally didn't know.
Somebody did,
Somebody should have.
or did.
They did, probably didn't because you weren't very cooperative with the situation and getting your hands restrained was our first priority.
You don't remember whether or not it was taken out of my hand?
I don't remember in which order it was taken out.
Well, then do that mean you mistakenly wrote this up the way you wrote it up? If you don't remember that?
I wrote it to the best of my knowledge.
So. I'm sorry. He's not here, so I can. But anyway, let's talk this through. This was June 6, 2023. Our first encounter, our first negative encounter was October 13, 2022, correct?
Correct.
That day, before that day, a little bit before that day, do you remember asking me if I wanted to be a trustee?
No,
You don't remember? Of course you don't. Do you remember any officers referring me to you as a trustee?
no,
Not beggars?
no,
No? Okay. So do you remember me asking you, can I be a trustee? No. You don't. Okay. So that day, when I supposedly threw feces on you,
mhm,
when at that very moment when I threw the substance on you, did you smell feces
instantly.
instantly? Oh, of course you did. So let me ask you this.
Your Honor, I'm going to object to the sidebar.
Sustained.
Oh, sorry.
If you're-
Sorry about that.
All right, you have to follow the rules, so, okay, go ahead.
That day, I so-called threw feces on you, right? Do you remember how that situation even started?
I remember the events earlier in that day, you had dashed the trustee with PC. I came to speak with you about it. And you had refused to come out of your cell because I was going to move you.
So nothing happened before that?
I'm aware of it.
Do you remember me writing a grievance about the situation?
No,
Do you remember me questioning you about my property?
after you were moved to isolation cell.
Do you remember what happened to my property?
No, I did not.
Who's responsible for an inmate's property after they get moved?
Well, depending on the condition of that property. That property and everything in that cell was covered in feces, including myself and another officer.
Who put the feces there?
You did.
I threw feces all over my own cell,
4 milk cartons full, yes, sir.
all over my own cell.
It ended up in your cell as a result of dashing us.
So you have no recollection about Ricky Johnson squirting waste into my cell.
No.
That's the witness.
State any further questions? Go ahead.
Just real quick. So the lunging part is while they're on the floor, am I right?
Yes.
You are on the floor on top of him trying to restrain him. Now you put the report that you restrained him. Does that mean y'all got him on the floor?
He was subdued on the floor, but he wasn't completely restrained at that time.
You can see that y'all are down there for a little while on the ground. aren't you?
Yes,
If it was just real quick and everything was fine, y'all would have been right back up.
yes, we would have stood him right back up and tried to escort him, so,
But it took a while to get it fully under control. Is that right?
yes.
And then the pins came out later. You can probably see a white cloth being thrown out after y'all get back up.
Yes.
Absolutely.
All right. Anything else, sir? No? Okay. Is this man excused?
I have no objection, Jim.
All right. We're going to take a break, ladies and gentlemen, for lunch. Can all of you return back at 1:15? 1:15. And if you go to lunch with a fellow juror, talk about the weather, everything else, but not about this case. Okay, thank you. Everyone else remains seated.
Judge, he just got to put that exhibit up
Okay.
that he tendered in, so make sure. So we have it for the record.
Everyone else remain seated other than the bailiffs and the jury. The jury may exit first. Thank you. Thank you. And we are in recess until 1:15. Thank you. And we now recall clause number 23 CR 727, the state of Texas versus Raymond Peoples. The defendant is present, the state's present, and is the jury ready? Kendall,
We'll get checked.
thank you. Mr. Laird, you have one more witness, I think?
Yes, sir.
Okay. Record shall now show that the jury is present and seated in the courtroom. Ladies and gentlemen, we had to take some matters up so that we could finish all of that and then focus today on this trial. So we're not going to get interrupted again. We were able to take care of all that business. So we're going to pick up where we left off here. The state was presenting its case in chief by calling witnesses, and the state may call your next witness.
Matt Gardner.
Gardner, please come forward. Please raise your hand, sir. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Go ahead.
You state your name, please. My name is Matt Gardner. And how are you employed? I'm a detective with the Jefferson County Sheriff's Office. And how long have you worked with them? This is my 24th year. And how long have you been a detective with them? I began criminal investigations back in 2017. Back on June 6th of 2023, were you a detective with the Jefferson County Sheriff's Office? Yes, sir. And did you get assigned a case where an inmate had attacked a guard with some pins? I did. And who was that inmate? It was Raymond Peoples. And had you had dealings with Raymond Peoples before and after that? Yes. So you know Raymond Peoples. And do you see him in the courtroom today? Yes, sir. And you point to him to describe an article of clothing he's wearing. He's sitting at the table with the white shirt. Record reflecting that identify the defendant.
Yes, it will.
So when you got this call, how long after the incident did you get asked to come and look at this? I was on duty at the time, so it was very shortly after. The scene was still trying to be preserved for us to view it and document everything. So when you got to the scene, where was the scene at? Let's do that. So we have 2 maximum security dorms. Every dorm has a letter from A through Q. M and N are the 2 maximum security dormitories. They each have a 6-cell isolation hallway, and then inside they have 48 cells with bars instead of solid doors. And we were in the isolation hallway for Northern. It was just the phonetic words for the letter E. That's what we call it, Northern. Was it the specific cell that you were called to go to? Cell 6 is the last one on the hallway. So did you go there? I did. And with our forensic staff. Did you look around just to kind of see what the hallway looked like, what the cell looked like? Yes, sir. Was there anything unusual inside of the cell that you found that caused you to concern, or was all of it outside the cell? Nothing I recall inside the cell, just some items in the hallway. So looking at State's Exhibit 6, is that the hallway you looked at? Yes, sir. And when you looked, was this door already open? Yes, sir. And was this on the ground over here?
Yes, sir. Some, looks like some bed linen.
And then down the hall, what's this down here?
I believe that's where we found the sock and the ink pen.
Let's look at State's Exhibit 22. What is that? That look like some papers and things right there?
Yes, sir.
And 20, let me look at 5. This is a little closer to the blankets, isn't it?
Okay. Yes, sir. I think that's the sock.
Okay, is that the sock right here?
Yes, sir.
And what was the purpose of that sock?
It had been wrapped around one of his hands. I'm assuming to protect his knuckles if he was to fight with staff.
Okay. And down where those papers were, let me show you what's marked as State's Exhibits 34, 35, and 36, and see if you recognize these.
Yes, sir.
Do those fairly accurately depict part of that hallway where you found the pen at?
Yes, sir.
Chandler Estates 34, 35, and 36.
Okay, State's Exhibits 34, 35, and 36 are admitted. Thank you.
Looking at 34, going back to 32, these papers that were laying in this hallway. Does 34 show a little closer view of those?
Yes, sir.
And what do we see over here in this corner right here by those papers?
That's the ink pen.
Okay. 35 just closer to the papers, is that correct?
Yes, sir.
And 36, what is that?
That's a close up of the ink pen.
Now, when y'all went and looked, that's kind of looking at this hallway. Is this the cell door leading to number 6?
Yes, sir. It's kind of a dark photo, but you can see the yellow lines going horizontally. There's 2 leading up to each cell door, and you can see a small portion of that line at the open door.
You're talking about lines like this.
Yes, sir. Those double lines are for the inmates to stay within when they're walking.
So right here, when you're looking, is that part of that one line in front of 6?
Yes, sir. Because beyond that cell, there's a storage closet, but that line helps you understand that that's actually a cell door.
So there was a lot of scuffling going on between this area right here, wasn't there?
Yes, sir.
From what you heard from looked at witnesses, and you also viewed the tape, didn't you?
Yes, sir.
So this pen that was in the defendant's hand, it ended up way down here where these papers are, didn't it?
Correct.
Looking again at States 34. That ended up down the hallway. With the scuffling, was there a lot of kicking and things, stuff was scattered, wasn't it?
It was chaos from what I viewed.
And did you go and lift up any of the blankets and everything, or did y'all just go take pictures of the blankets and the pen and what all y'all found there?
We took pictures of everything before anything was moved.
Okay.
And then we looked.
And then did the trustees come and clean up a little bit? And were there also a bunch of guards that were down there with them? When you look at the video, you don't know what they're doing with what, do you?
Right.
So were you able to find both pens?
Just the one.
And is that unusual when things are a little small like that, getting kicked around?
Not in the jail settings, nothing.
Let me show you what's been marked in State's Exhibit 38. See if you recognize what that is.
This is evidence I submitted on June 6th of 2023.
And what's contained in there?
One plastic ink pen and one white sock.
And is this the one that came from the outside, the one we just saw up here, outside of cell number 6?
Yes, sir.
Tender States 38.
No, George.
It is admitted.
These were kind of wrapped up in gloves, weren't they?
Correct.
Objection.
What's your objection? What's your objection?
Say anything about any gloves?
Okay, your objection's overruled, sir. That's inappropriate method of making an objection. Go forward.
Was this one of the things that was supposed to be wrapped around his hand?
Yes, sir.
That's what the conclusion you came to?
Correct.
Was there other things that they saw wrapped, but there were some things wrapped around his hand?
It was either a piece of fabric or possibly a blanket itself.
And is this the pen we're talking about?
Yes, sir.
Now, when this came out strapped to Mr. Peoples' hands with another pin strapped, were they being used as pins at that time?
No, sir, they were intended use of them when they used weapons.
And by using a weapons, was a pin like this capable of causing bodily injury?
Absolutely.
Is it capable of causing serious bodily injury or death if you get him in the right place?
Correct.
And in the manner that Mr. Peoples was using it when you're watching the video, talking to the witnesses, was it capable of causing serious bodily injury or death?
Yes, sir.
People in the jail use all kinds of things, don't they, to stab people with?
You'd be surprised. Yes, sir.
Is a ballpoint pen or a pen one of them?
Absolutely. I worked one of those cases just a couple of weeks ago.
What was that about?
An officer was stabbed in the face with a knee pin, and as the inmate was fighting with him, it was still penetrating his nose during the fight, barely missed his eye.
In this case, we had injuries to Lieutenant Ford, didn't we?
Yes, sir.
And looking at State's Exhibit 16, were these the injuries you saw on Lieutenant Ford that day?
That's some of them. There was more on his neck and chest.
And we're going to get to those. State's Exhibit 12, what is that?
It's the right side of his neck, some more abrasions.
And State's Exhibit 13, what are we looking at
That's
here?
the upper middle chest.
Now, when we're looking, was there some allegations that Mr. Peoples had scratched Lieutenant Ford's head with his nails?
Yes, sir.
And do you see those type of injuries on the sides over here and on his neck?
Yes, sir.
State's Exhibit 12 and 16. And also, do you see one that looks like a scratch on State's Exhibit 13?
Yes, sir.
Do you also see on State's Exhibit 16 evidence of a more sharper instrument coming down his face?
Yes, sir. There's more of a puncture wound with the drag.
And then looking at number 13, does this look more sharp than a scratch with the nails?
Yes, sir.
Does that fit the testimony or the statement that you took from Arliss Anderson, where he said he was stabbing him with the pin and raking it down from the side to his chest?
Yes, sir.
Well, for the record, you're using the pronoun he, several he's are involved.
That's Mr.
You would help the
Peoples.
record show who's responsible for what actions, so he isn't mixed up later. And people try to figure out what's in the record. Thank you. Go ahead.
Was Arliss Anderson's statement about Mr. Peoples, was it consistent with what we see in these photographs of a pin being used as a weapon against Mr. Ford?
Yes, sir.
And so after you looked at all this and after you talked to everyone involved, did you come up with a conclusion of what kind of charges needed to be filed?
I did.
And what charges did you file against Mr. Peoples?
The appropriate offense to charge would be aggravated assault of public servant. Because he was acting in sufficient capacity, discharging his duties when he was assaulted with a weapon capable of causing serious bodily injury.
And his duties, was he moving Mr. Peoples within the jail from one place to another?
Yes, sir. The maintenance department was decommissioning cells one at a time to do some very necessary security upgrades, and Lieutenant Ford had been ordered by his captain to remove the inmate, whoever it was, from that cell and rehouse him so they could get to work in the cell.
Okay. Was there anything else that day that you had dealing with Mr. Peoples? Or did you, I know you said you had dealings with him before and after, but was there anything else that day that you had dealings with him?
Nothing that day I recall. It was just, I completed an arrest affidavit so we could go ahead and give him a rein on the new charge.
Okay.
And Lieutenant Ford was taken to urgent care.
Is he, to your knowledge, still in isolation?
Yes, sir.
And does he keep staying in isolation because of his behavior?
That's my understanding.
Okay, I'll pass with him.
Mr. Garland. You say you have had dealings with me before and after this, correct?
Yes, sir.
Before this, what dealings did you have with me?
I don't recall before what it was.
Do you recall after?
Yes.
What was
Would we like to talk about last Friday?
last Friday?
just filed a harassment of a public servant case on me for dashing an officer multiple times.
You talked to me about this?
No, I didn't talk to you about it.
So when you say dealings,
With work in relation to you yesterday,
so when you say I dashed a officer with what?
urine feces.
And what officer was this?
That was, corrections officer Boyce.
And you say you charged me with this when?
I submitted the case yesterday. It's pending grand jury done. It was heard Friday.
Okay. And who told you that I dashed him with feces?
One of the supervisors let me know. They send emails to me every time a criminal incident occurs in jail.
Did you talk to him yourself?
So who?
To the officer that I supposedly dashed with,
Yes, sir.
and he told you what?
He told me that you dashed him with urine and feces. And that's what I observed on video, and that's the case I followed.
All right. So you wrote have we ever physically talked?
Not that I recall.
Not that you-
I've talked with hundreds of inmates in the time I've been in internal affairs.
But you never had a personal conversation with?
I'm not sure if I have or not.
Okay. Almost there. You want to? There we go. Sorry about that. So, Your Honor, may I approach the witness?
For what purpose? Tell me.
Evidence to tender evidence of me and the witness prior dealings.
Well, if you're gonna show something,
I want to,
the proper, you need to mark it for the
but I have to
purposes.
make sure that
As
you
in,
recognize
no,
the
you,
evidence.
whenever you tender something, you mark it first, then you tender it. If it's not going to be used, it's just in the file as an unused marked exhibit. But if you're referring to something, you need to mark it first as an exhibit. And we've got, do you have the exhibit stickers to mark? A defendant's,
there.
all right,
I gave some just.
get him one, let him mark it. That's going to be I think that's going to be defendants one, isn't it?
No, two. You
Two.
do a couple.
Don't get.
Well, for record purposes, you have to mark it so that you know what it's.
I know that, but don't you have to confirm the evidence before I say it?
Sir, once again, I was on the Rules of Evidence Committee. You have to, you have to mark it first, and that's how it will be seen in the record. Yeah.
But you fake niggas, three of them won't get it.
And much of this is done for posterity's sake. If something is reviewed in the future, the people who are reviewing it need to figure out, be able to read it like it's a novel, what's happening and what is being referred to. Like this paper, I'm going to show you this paper, and well, what was that? It has to be referred to as an exhibit, so folks can keep up with the identification of items. Okay, you have something called Defendant's Exhibit 2. Okay.
Exhibit
Go ahead.
2 and 3.
And 2 and 3, go ahead.
The finish.
Jump down first if you recognize them.
Yeah, you're gonna approach him.
Wait. Take off. Wait. Your Honor, may I approach the witness?
Yes.
Do you recognize Miss Jessica Gardner?
Not this.
No,
I don't know. I don't deal with indictments.
Yeah, no.
Yes. It's a report that I wrote, for implements of escape.
Yeah. May I put this on?
No, sir, it hadn't been admitted yet.
No, tender.
That's why I've asked you, please, if
You
you need
switch up
somebody
the-
to
you
stand
switch up the
by.
routine all the
you've gotta-
time, Jeff.
Sir, you've got to act under the rules of law as lawyers are required to do. And when you represent yourself, you have to put yourself in as though you were a lawyer. That's why anytime you want to change your mind and get a standby counsel, let me know.
I don't think
Because
you
you want to do,
This
we
ain't
got
how y'all
to
explain
correct,
the
we have the
routine.
rules, sir.
That's how y'all explain the routine.
Judge, since he identified three, I don't have any objections to it. Two. Yeah, he said he couldn't identify it. I'll object yet, so
Okay.
I don't mind three coming.
I'm sorry, what did you say?
I object to two because he did not identify it. It's an indictment. It's not properly formed, but the other one I'll let in.
Okay, hold on. So you
I don't
have no
any objections.
objection for defendants 3, but you are objecting to defendants 2?
Yes, sir.
All right, let me see that. Let me see.
Two. He needs two.
Yeah.
Oh, you need, no, you say you need 2. No, sorry.
It's just like two.
This is 2.
Okay. You had a 2 like a 9.
Zero.
That was me.
Is that what you did?
You know my handwriting.
Am I
Defendants 3 is admitted. You can refer to that.
allowed to put it on the bulletin?
3? Yeah.
3, yes.
Yeah, it's admitted.
Mr. Laird,
Just-
did you?
I told you, you can just.
Display.
Okay.
I can turn it on.
So, wanted to, I'm gonna go ahead and read out this whole thing, the paragraph or whatnot. 'Cause you say you remember this report, but you don't remember talking to me ever, right?
Sir, I said I talked to hundreds of inmates. I didn't recall if I'd had a personal conversation with you.
Okay,
I filed so many criminal cases for things that happened in the jail. I can't recall the facts of every single one independently.
so do you normally talk to the inmate before you file those charges?
It depends.
It depends. What do it normally depends on?
That's just an open-ended kind of question. I don't know how to answer that for you.
I mean,
It could depend on any number of the factors.
okay, let me ask you this
Every
factor.
situation is different.
Let me ask you this factor. So if there's not enough substantial evidence to charge an inmate with a crime, would you consider talking to him then, or do it matter?
If there's no evidence, I don't file a case.
Don't file a case. So if there is evidence and you file the case, it still varies whether or not you would talk to him?
Yes, sir.
Okay. So on the escape charge, right? What would vary in this type of situation for you to talk to an inmate?
What do you mean by that?
Like for you to meet with the inmate and talk and discuss if the inmate, whether or not the inmate was trying to escape, right? His intent for you, what would have to, what type of aspects will have to vary for you to say, okay, well, this is enough for me to go and meet with this inmate to talk to him?
Well, your intentions were pretty clear on the video, but I wanted to ask you if you could explain what your intentions were.
Oh, okay. So you wanted to ask me to explain, even though it was clear, you wanted to ask me.
Yes, sir.
Why is that?
To hear your answer.
To hear my answer. So if it's necessary, if you feel like that was necessary to hear my answer, even though the evidence was clear, right? Why didn't you come talk to me before you filed this case yesterday? To hear my
Because I
answer
didn't
on
have
it?
any questions on that one.
I mean, it was clear that I did it, right?
Yes, sir.
So why didn't you have questions?
Because I didn't need to know what your intentions were when you propelled a liquid combination of urine and feces onto one of our staff.
How do you know it was urine and feces?
Because of the odor and the appearance that the staff explained. in
The
their
odor
reports.
and appearance.
Yes, sir. It's a pretty distinct odor. I think every reasonable person's aware of that.
The odor and the appearance.
Is that a question?
So the odor, I'm assuming you talked to him immediately after I dashed him, correct?
No,
When did you talk to him?
I talked to him Friday, but not immediately after.
the same day though, correct?
I don't recall if it was actually Thursday or Friday, but it was last week that this happened. But I worked the case Friday, and it was probably Thursday morning if it happened. But again, I don't have that in front of me to reference. I work so many cases.
No, that's so is it normal that you would wait days later to talk to a CO after
Not days later, but like I said, sir, I receive emails daily from the jail supervisor. Anytime there's a criminal incident, I get an email. I get reports attached.
All right,
And I said I worked this case Friday. I believe that the actual incident occurred Thursday. So when I come in Friday, I have that email from the conclusion of that shift saying when it occurred.
okay. And did you collect the evidence of his clothing?
No, so we photograph it. We don't put that in the bag
Why not?
because we have photographs of soaked clothing. We have video of it occurring coming out of a cell with one sole occupant that was used.
So
And because the statute itself does not require that it's actual urine and feces, it can be any fluid thrown onto any person in a jail. But it's just a little bit of an aggravating factor for you that it's urine and feces and not just water.
so you say it can be any liquid.
Yes, sir. If you dash an officer with a cup of water, it's a 3rd-degree felony.
Okay. So in this instant, right? Correct. In this instant, it wasn't water, right?
That's what they said.
Which means it would be DNA, correct?
I'm sorry, ask that question again?
Which means there will be DNA on his clothing, correct?
I would assume there would be.
So wouldn't it be more of a what's that word I'm looking for? Procedural to collect his clothing for
And excuse me if I'm a Matlock fan.
DNA?
The proof of what the substance is not necessary to establish the elements of the offense.
So
Is he saying BNA?
give a person life in prison just because you feel like it? Is that what it is?
It's a 3rd-degree felony, sir. That's 2 to 10 years.
So I'm asking, is it
This is not a fair fight. This witness is not stupid, and this defendant is.
is it normal for you to not collect the evidence before you charge a person with a
It
crime?
depends on the offense.
On an offense this serious, is it necessary?
It's not necessary. We have photographic evidence and we have video evidence showing the offense occurring.
Do you agree that offense is very serious?
It's serious.
Very,
It's a
right?
pretty serious violation of somebody's personal space when you put your bodily fluids on them.
Right. So with that being so substantially serious, why isn't it a part of procedures that you collect the evidence before you charge?
Because I have photographic and security video evidence showing the offense occurring, and it is not necessary to have the substance tested to confirm what it is to meet the elements of the offense to charge you.
Okay. So, but we do agree that we have personally met before.
It would appear so, yes, sir.
Would appear. You remembered once you seen that paragraph that we
And
met.
once I saw the report that said implements of escape, I remember the time you attempted to escape from your jail, yes, sir.
All right, and remember us talking.
I don't recall the conversation. It's been a while.
No. Would you, Mr. Laird, would you happen to have the evidence on that since the detective is testifying? The implements for escape?
Are you talking to me? You're the one who's supposed to be prepared for trial. I can put a whole lot of stuff in here. if you
Well,
want to.
You wouldn't,
I don't want to do that. I'm trying to avoid doing what you're
you wouldn't allow me to prepare, adequately prepare because you were supposed to tell me.
I'm sorry. You don't, this discussion is going to be in,
Okay, it's all right.
This is discussion, you can hold it at a different time, not in front of the jury. My goodness, that's not appropriate. If y'all need to discuss legal issues, do it outside the presence of the jury. Ask the questions. The jury is just here to determine what the evidence is, not what's going behind the scenes, okay?
Okay.
Ask your next question of the witness. That's the proper procedure. Thank you. Go ahead.
All right. So after me and you met and talked about this, do you remember why you charged me? Let me reiterate that question, sorry. Do you remember me telling you I had no intent to escape?
I put that in my report, yes, sir. That's what you said.
So is there a reason you would charge me after I said that?
Because as I said, your actions on the video were clear. I just wanted to hear if you would tell me why you were doing what you did.
Okay. So is there a reason you didn't draw up a probable cause affidavit for it?
I believe you've been indicted on that, so I would have. Again, this is not the case I'm here for today, so I don't have those documents to reference.
No, I mean, it's in reference of the case because we are talking about my behavior, correct?
Yes,
And this is a part of my behavior, correct?
absolutely.
So it's very clearly referenced to this case, right? In jail.
Sir, I don't bring every case file for you to a trial for an aggravated assault. I just have that information on aggravated assault.
I mean, if you wanted to prove my behavior, being so atrocious and monstrous, wouldn't you want to bring that evidence to trial?
So I'm not here to prove your behavior, I'm here to answer questions.
Right. And I'm here to answer, correct? I mean, I'm here to ask, correct?
Yes, sir, ask for it.
That's why I'm asking about this. Right? So that's why I'm asking. Why didn't you drop a probable cause affidavit for this? And
Sir, I said I did.
oh, you did?
That's how you get indicted. I have to request that the warrant be issued for your arrest and follow the call like that.
Have it. You know, it's probably cause that.
Yes.
There you go.
Because when y'all gave me this, I never got it.
No, sir, hold on. We're here on an indictment for aggravated assault against a public servant. You're bringing up now other types of misconduct. That's your opening of the door. That's your opening. That's not what this jury is supposed to
No,
be.
he
And you just interrupted for the
I'm sorry.
time.
Sorry.
This court.
Sorry, Your Honor.
Please follow the rules. And once again, this lady has to take everything down. And when you interrupt and speak over the court, she can't take two people speaking. And that's what the rule of law is. When the court speaks, you have to stop. You have a fair opportunity. But we learned this when we were children.
Yeah, we did.
Okay, well, follow those rules, Mr. Peebles. You're able to do that. I know that. All right. You brought this.
I don't know. This guy is so profoundly stupid. I don't know if he can understand and follow instructions. And I'm not being facetious.
Extraneous type behavior out. That's what you're doing. The four corners of this indictment are what happened on or about June 6th, 2023, in result to this first degree felony indicted of aggravated assault against a public servant. So if you want to go into extraneous acts, number one, they have to be relevant to this case. And number two, that was something that if that was your plan, you should have inquired with the state on any discovery. And in the middle of the trial, it's hard for them to stop what they're doing on one case and then go look for something when it wasn't indicted.
I want to dumber down the ticket. I want to fight that.
So you think about that. I don't know if they have information, and I don't know what you're heading for in bringing this up. But again, we're talking about the jury's chore and job is to determine whether or not it has been proven in this case that you were guilty beyond a reasonable doubt of aggravated assault against a public servant on or about June 6, 2023. Other extraneous type behavior can be relevant only under limited circumstances, because the general rule is you don't throw every bad thing into a jury, in front of a jury. It's what's relevant to the allegation of this indictment. Some people have numerous indictments. Each trial deals with those specific facts. But right now, we're just focused on this one, this indictment. That's for the jury to determine. So let's try to focus on the relevant facts for the allegations in the indictment. That's what they're here for. Go
Yes,
ahead.
Your Honor, absolutely. But I would like to note to the court that the court and the state tendered this evidence for me to question the witness. So, I mean,
I didn't tender it to you, but the state did. And if what is it that we're trying to focus on if it's not one of the elements of the crime in this charge? Why are we straying? Because this could last, theoretically, this could last 100 years. And it's not funny. That's why relevance is the whole essence. You deal with one charge at a time, and you deal with every fact situation in a charge, and a situation has its own circumstances. And that's why sometimes we try many cases with the defendant. But we're trying to focus on this one trial, this allegation. Other allegations that don't have relevance to the elements of this crime are irrelevant, and for another time, another jury, another indictment.
right.
Okay.
The state asked him if he had dealings with me before and after, and he also asked specifics about my dealings also. So I figured if he asked about other dealings, I mean, I could ask also. I mean, seeing that the state is holding me to the same standards as a.
Here's your probable cause. If you want anything else, then I'll give you anything on that charge you want. You can see all the. I'll put it in myself if you want me to.
So I gotta ask, why wasn't this a part of the stuff you gave me for trial? When you was
I had no intentions of trying that.
Once again, y'all's discussions outside the presence of the jury, just y'all can
Judge,
talk
if
about
we need,
this
if
at
we need
another
to take a
time.
break for him to look over this file, I'll be glad to let him look over the file. If you want to give him 5
Just,
minutes break,
just
I'll be glad to let him
don't
look at
bring the
everything he
jury
wants to look
into
at.
discussions that are not relevant.
Well, I mean,
Their
y'all
determination.
brought me out here 2.5 weeks ago.
Sir, just ask questions. You ask whatever questions you need to, you have a witness, ask the questions. Don't be discussing this in front of the jury. We can do this outside the presence of the jury.
Yes.
It's inappropriate for the jury to hear things that aren't evidence for the crime at issue. Please stay focused on that.
I need
Thank
a
you.
5-minute recess to ask him about the other relevant evidence to both of these cases, because I feel like,
We can do that later. Ask, what other questions do you want of this witness while you have him here?
well, for me to adequately construct my questions to the witness, I need to make sure my knowledge of both cases is up to par, because it looks as though I'm missing information to both cases.
Okay, here's what we're gonna do, ladies and gentlemen. We're gonna take a short break. I don't know how long this will take. Please bear with us. And relax, stretch your legs, and we'll bring you back in as soon as possible. Thank you.
I have a question.
No, we're in recess.
You're supposed to be reading.
No, I don't have to. We're supposed to be talking about me giving.
No.
I'm fixing to get a copy of this for you.
Oh, Mr. Larry, can you please, okay, he said he charged me.
You like it if someone puts your vagina on Facebook?
But I haven't been arraigned. Can you please?
I don't have that because it hadn't been in front of the grand jury, so it's not something that I can give out to you.
When he had a problem.
You brought it up, I didn't, and the reason you do that is you don't bring that stuff up because it's not been indicted yet. I haven't touched it, you have.
I'm tired of
I'm tired of arguing with you. I'm gonna give you this.
trying to argue with you. I didn't bring it up. I didn't know he charged me with it.
No, you want him back?
You
You want him in the back? No, the other inmate wants some water. I'm gonna keep him.
Let's go out there and talk to you. Not with me, sorry. Mr. People, do you still have the PC affidavit? Yeah, let me have that. I'll get you. No, it's not that one. You don't have to. The one my certificate. You did whatever it is.
It should be 4. Is that 4 on there?
Yeah.
That's it.
Fine.
I'll bring it back to you.
Tom Kelly.
Yes.
Allow me to see life in prison in front of the world. So if we bring it in, we talking about it. Ain't nothing about it. You care. Sweat under the rug. All that limestone. And so, no, we talking about everything. Y'all have to push this box. Cause I'm bringing up everything. You might secure it today. You know, I don't want to. You know. Make sure. And that's all that from my boss, here, we say. Mr. Gardner, have you found that?
We're not, sorry.
Sorry. Sorry about that.
You know, like over your stuff, Casey's gonna question you about it.
Mr. Larry, have you found it with the DA though?
What?
The charge, you know, charge me with that, you know, favor.
He's given it to my office. I have not got a copy of it because I don't do grand jury. It goes to the grand jury. Before the grand jury looks at it, it's not officially a warrant or anything for you. It's just there. It's gonna be taken care of next week, but I don't know why you won't get into all this. It's hurting you, not me.
I didn't know he did this. He was. He brought this. I do. That was new information to me.
I'm done.
You know,
Done help.
I don't play with my feet. I don't play with my girl shirt. No, I do not. I got plenty of witnesses in that jailhouse that would tell you. If y'all would let me call. I plenty of witnesses that would tell you I never played with my feet. So we don't have to get some DNA on that. And yeah, I dashed in with water because they took my vehicle.
You get that on the record.
I know that's still a shock.
Felony 3.
It's the same office.
You could try it.
Hey,
Yeah,
just, we're not doing this.
Matt, just, we're gonna stop, Matt. We're just gonna let him do things.
Let's go to the back. Well, we're gonna go in jury room. So when was this? This was after.
Huh? Yeah. Yeah.
Probably I'm talking to myself. And
This is copies, this is copies, right?
All business.
It's copies, right?
So let me do this thing.
Mike, you just made him copies, right?
Yeah.
That's, yeah, okay, so y'all got your.
I got my copy, that's his copy.
Okay.
He's free to bring up all the stuff he wants to. I'm going this way. You going out here for a minute?
He's coming that way. So.
Oh.
This please.
Oh.
Matt,
That might be step over.
Come this way. That, Nick, just wait.
All right, all parties are present. We're ready to proceed. Please bring the jury in. Thank you. Tom, do you need me on something? Tom?
No, Your Honor, I was just here hiding. Thank you for noticing though. Hopefully not.
You may not be aware of this, but you stick out. You're the tallest person in the room. If you're gonna hide, go to the basement. You gotta go to the basement.
Bring back Giles, I'll hide where I have to go.
It's using my courtroom as a hiding spot. And the record shall show the jury is present, all parties. Thank you for your patience, ladies and gentlemen. Let's see what happens next. And the defense, I think, Mr. Peoples, you're up and you're asking some questions. Go ahead. Take over. There you go.
Have I wrote a grievance to you? You don't pay attention at all?
I answer thousands of those. We have almost 900 inmates, maybe more sometimes. And I answer those every day. So I have no idea. I haven't focused on any one particular inmate, just the inmates.
How often do you read a report about me?
I also have no idea. I read reports about hundreds of inmates every month.
Don't nobody ever mention
Was it showing that picture? I just wanted to show the picture for a second. And it wasn't showing here. Oh God, I'm sorry.
me to you or bring me up about anything,
Yes, this is high quality professional entertainment.
situation,
Like the
other than, the stuff you tried to do? Nobody ever brought up to you about me causing problems in the facility?
I'm not part of shift meetings to hear any of that stuff. I have an office. I'm not part of the jail staff.
So this is the first time you heard
Somebody in the chat asked if Brecken was my daughter. Come on, people. Brecken's older than me.
about me throwing feces on the office.
No.
You have heard it before.
Yes, in the case we're here for today, the last paragraph of my report.
All right. Other than this one, has there been any other?
Other than those two?
Yeah.
Not that I can recall, but I would have to look through my spreadsheet to see how many times your name is on it.
Lieutenant Ford, when you claim I dashed him in feces, were you working at Jefferson County Correctional Facility?
No.
So how did you know about that?
Because he told me.
So is it fair to say that other people do tell you about other times that of my behavior throughout the facility?
If it's relevant to my investigation, I ask the question.
Have anybody ever told you I punched any other officer?
I would have to refer to my spreadsheet to see if your name is on there for the assault case. I don't recall. I don't have an eidetic memory, sir. That's why I have notes in the spreadsheets.
Well, I asked you that because I wanted to ask you this.
Yeah.
If you never heard of
He's a
me
good man.
throwing waste on any other officer but Lieutenant
Guys
Ford,
get it.
right? Right. But you wasn't, I think you wasn't here. Okay, no, let me read that question. Why didn't you charge me with throwing the feces on Lieutenant Ford once you found out about it?
Because I was not the detective assigned to internal affairs at the time.
If you want to see ugliness in this world, you can just look at the flamingos when one of them's wearing the other one's shirt. Oh yeah. Oh yeah, that makes the Middle East look like a calm situation.
There was no resources preserved for me to present the case. I didn't have video and photographs. Otherwise, I would have.
And it's on record, right?
What do you mean?
Like, you put it on record that I bashed him with, I threw feces on him,
I
correct?
made a report, yes.
In that report, did he request criminal charges to be brought against him?
That's my understanding, yes.
So why didn't he?
Why didn't I?
Yeah.
As I said, sir, I was not the detective in internal affairs at the time. I was downtown with the criminal investigative division.
Would that really matter?
Yes,
You don't have to have knowledge of a crime and proceed, even though you wasn't.
sir, I was working in special crimes, helping young children and female victims at that time. I was not working in any cases with the jail. That detective is since retired. I cannot speak for him about why he didn't work the case back in 2022.
Has that ever happened when a crime that that happened that you wasn't around and
But I
you,
don't care.
that used to be under somebody else's name, you never came back and pursued charges?
We've all worked cold cases, but those are homicides that we do. We don't bring up incidents in jail from the past and relook at it.
So you are allowed to prosecute cases that wasn't under your name before.
I can. But that was not my job to do that. I didn't have any evidence preserved to present a case.
Testimony will be evidence, correct?
Sir, would you be comfortable being charged with an offense with no evidence to show? No video, no
No.
photographs?
I wouldn't be.
Okay, that's why I didn't present a case on you for that.
So
To be fair,
if that's why, right, do you think I would be comfortable with being charged with a crime that you also have no evidence on as far as DNA?
I don't need DNA for a harassment case, sir. It can be any substance whatsoever. That's what the penal code says.
No, it says bodily fluid. It
I'm
never-
sorry. No, sir. You're not, no, sir. This isn't a debate with the law. I will give them the law. Ask him a question. Ask him a question. Don't debate over what the law is. Thank you. That's my job. Ask your next question. If you're going to represent yourself, you have to do it properly under the rules. Stay within the rules. I've said this numerous times. It's not a debate. You ask him the next question.
Pass the witness.
What did you say, sir?
Pass the witness, I'm done.
Anything else?
No.
Is this man excused?
Please, sir.
You are excused, sir.
Thank you, sir.
Next,
Let's take a rest, John.
you're up. What do you want to do?
Yeah, well, I mean, of course, you're not going, if I ask you to be a witness, of course, you're not gonna do that, correct?
You were supposed to do that
I want to.
when you represented yourself. That's what they do. And I asked you, get some help, and you refused it. They're the ones who know how to do it. You don't do it in the middle of the trial, sir. These people have work, things to do. You're supposed to be prepared. You said you were ready. You insisted on moving forward. But we can talk about this at the lunch hour. Is there anything you want to bring up other than,
Testify.
you do?
Yeah.
All right. You may call yourself and come forward.
Call myself, except
Yes, sir. Have a seat, please. Raise your right hand. Do you solemnly swear or affirm any statement you make during this trial will be the truth, the whole truth, and nothing but the truth? So help you God.
God.
Lower your hand, please. Please sit, be seated. Ladies and gentlemen, when a person wants to represent themselves and make testimony, we don't have anything built into the system where we play like a question is being answered. And this is question and answer. This method, when a defendant wants to represent themselves, it's different altogether. And this is the exception to the rule. He may make a presentation, an oral narrative. And then when that is completed, then the state gets to cross-examine. But it's not a question and answer. In this particular case, when a defendant insists on representing themselves and testifying, they get to make a narrative statement, and they're going to be held to the rules that it needs to be relevant. It's to the allegations at issue in the four corners of the indictment. All right. You're on the stand. You've been sworn in, Mr. Peebles, and you may go forward. Thank you.
I'm a 37-year-old man. Born in 1988. I moved to Texas when I was 18 years old. I was born and raised in Detroit, Michigan. I have I have 4 children, 3 boys and a girl. First time I've ever been charged with a crime was when I was 27 years old. I work out. I'm healthy. My health is in great shape. So if I start shaking, foaming at the mouth, looking as though I'm having a seizure, which I've never had in my life, it's because you're talking about something that you don't want me to talk about. And they are electrocuting me through this shock box that they got on my leg. They are electrocuting me through the shock box that they got on my leg because they don't want me to talk about the prior cases and why I'm in here and all the stuff that they've been doing to me since I've been incarcerated.
I mean, nobody really wants you to talk about anything because you're so stupid that you can't connect ideas, and it's painful.
Yes. Yeah, I'm very scared right now. You know, I hope my kids not watching this because I told their mothers to make sure they don't go to YouTube and watch these. And one of them 15, one of them 14, one of them 11, one of them 4. I'm disappointed in time and time again because they thought I was coming home so many times. I thought I was coming home.
No, they're disappointed in you and the fact that you're an abject loser. They feel like they failed in life, and they have.
But because I'm outnumbered by the government, and there's so many powerful people in the government that hate my guts, not because of what I did to them, but because of who I am. When I got arrested,
Well, yeah, you're awful. People look at you and they judge you by your character, and it sucks. That's the truth.
I was working at Nighthawk. It was contracted with several different plants. We did environmental service. I was working with them for about 2 years, very consistent. Also started working back in my old job at an arcade for kids. So I was working 2 jobs, and I was still able to make a lot of time for my children and my wife. I don't understand why these people want to keep me incarcerated so bad. I have filed numerous affidavits throughout the years telling them that I wouldn't file a lawsuit. They just let me go home. But I'm not about to sign for nothing, because if I do, I won't be able to get my job. That signing for anything is not enough. I've never been convicted of an extraneous crime before, and I'm not about to start now. I was a law-abiding citizen. I've lived 7 years of my life fighting for people in cases that they know I didn't do. So yes, I'm about to talk about every single factor from the day I was charged with the first illegal crime back in 2016, all the way up into this new crime that he just told me about, of some feces being thrown on somebody. and everything that I'm about to mention is on record. Or I have witnesses about it. And I'm about to educate the jury about the law that y'all keep breaking, about the rules that y'all keep breaking, and how y'all like to keep trying.
Educate us. Tell us about all the laws we're breaking. Tell us about it while you're incarcerated, big dummy. We're all fascinated. We want to learn from you.
To manipulate stuff to keep me in here. They talk as if they don't got a personal problem with me. This is my fourth trial. My fourth trial. And the only time they were able to get a conviction was when it wasn't a jury in front of me. And that conviction came from a probation violation of a charge that they had no jurisdiction over in the first place. It was supposed to be
It was supposed to be. They didn't have jurisdiction. I never had any other conviction except for a probation violation. How'd you get on probation without being convicted, genius? Oh, you didn't.
misdemeanor court, not felony court. $70 years. Yes, I'm about to exploit all this evidence. So I want to start by saying, I want to start by talking about this partial jury trial that's going on right now. It's completely unfair jury trials that they forced me to go through right now. Doing a jury selection 2 days ago. And then 30 minutes into it.
Now you're gonna cry. Where?
The judge don't sit up here and say, well, you need to make sure you ask the questions right and do all of this, because when the lady starts transcribing this, she's gonna need to. And it was 30 minutes into it. I said, y'all not transcribing this? We're about to.
Hold on, sir. Sir.
What?
Sir, let's get relevant here. You were charged with the first-degree felony of aggravated assault against a public servant. This isn't the time to make a speech of your whole life. Let's stay within the relevant allegation. And don't interrupt the court. I've said, how many times have I said that? You have a fair opportunity to be heard. The court is required by law to direct the law to the people, and the jurors are instructed. We are focusing the relevant matters of the accusation in the four corners of this indictment. Let's stay within this. This isn't time for your life story. If you are found guilty, if we go to the punishment phase, there are matters you can bring up that are relevant to punishment. This is only about the allegation. Please stay within the four corners of the charge. Thank you, sir.
The jury,
Yeah, your life story isn't interesting. We already know what it is. You're stupid and you're a criminal. Okay, next. Let's get back to the case.
the day I'm talking about is the jury selection for this charge. So
Stay within the four corners of the charge in this indictment. That's what's relevant. Thank you for following the rules.
that's what I'm doing. So there was no point in me objecting to what I was seeing on the jury selection paper, because he wasn't.
Once again, sir, this is with the four corners of what happened on or about June 6, 2023. Let's don't talk about jury selection. This was all, that's not relevant to the facts. Stay within the facts, sir. Please go forward.
The Sixth Amendment says the accused shall enjoy a speedy public trial by an impartial jury. The word impartial means fair. in the district, whereas the crime shall have been committed, which shall have been previously ascertained by law, shall be confronted by the witnesses against him, which means the witness that's against me shall have said that I did whatever they charged me with. And yesterday, that man sat right here and said, yeah, you scratched me. That's how I got my injury. He sat right here after we read out, the victim sat right here after we read out his report. And he said that his report was accurate. And he said, yeah, after he got done lying and perjuring, he couldn't help himself. He had to, you scratched me. That's how I got my injury. But yet I'm indicted for stabbing him with ink pen. And you're talking about standing before food. That's exactly what I'm doing. The four corners, matter of fact, all persons born or neutralized in the United States.
Naturalized, sir.
Naturalized, thanks for correcting me. You're right. Naturalized in the United States. Ooh, you know this. And you know it.
Sir, just please move forward with what you need to say.
Born or
Thank you.
naturalized in the United States. And subject to the jury.
Neutralized. And the screaming, you know this. Nobody knows what you're saying at all, dummy. You're just rambling aimlessly, mispronouncing and misusing words. That's all you're doing. It's mush.
Jurisdiction thereof are citizens of the United States. No state shall make or enforce any law, which shall abridge the privileges and immunity of the citizens of the United States. Last I checked, I was born in the United States. Nor shall any state deprive any person of life, liberty, or property without due process. Last I checked, me talking about how unfair a jury is, I had the right to do that because my right is being abridged. So I can tell the world and explain how my rights are being abridged during my testimony in the four corners of the.
My rights is being abridged. To his credit, he repeats it 12 seconds later and actually says, "R."
Indictment. Is that correct, Judge?
Sir, move forward and stay relevant to what the allegations are in the four corners. And
Nothing you said is correct.
please, for the 20th time, please don't speak over the court when I'm speaking. Sir, how many times have I said that to you? You have a fair opportunity to speak, but it's not on your terms. The law has its rulings. The rules of evidence have its rules, and you, in representing yourself, must follow them, whether you like it or not. You have to stay within the rules. It's just not a full-blown part where you have just anything to say without any restrictions. That's the way the rules were built. And you have to follow the rules and stay within the four corners. And this is what are the facts are that is alleged of wrongdoing in this indictment. Please speak to that. This is your opportunity. Go forward. Stay relevant.
Yes, Your Honor. but
Move forward, sir.
I would like you to let me know if what I just said was correct or not.
It wasn't relevant to whether the facts are, I give the law. You don't start quoting constitutional law. I'm going to give the law, sir. You just talk about the facts. Please move forward. These people have valuable time here. Let's stay within the rules. Give them what your version of the facts of this incident were. Please move forward. That's what we're here for.
So you above the laws of this country? I'm just asking
You, one more statement like that, and I must hold you in contempt of court. I don't want to do that. I've ordered you to follow the rules. Please follow the rules. direct your,
All right.
the attention of the jurors to the facts as you want to say them in this allegation. Thank you.
Nor shall any person be denied within the jurisdiction.
I give the law, not you, sir. Just talk about the facts of this case.
Equal protection of the law.
You're not going to follow the directions of the court and the rules? Or
I see how Jesus feel.
that's your statement?
I'm testifying, Your Honor.
To the facts of the case, sir.
So you tell me I can't be a character witness to myself?
In his defense, he absolutely does not have the cognitive ability to understand what is going on here. Part of this is pushback and a little bit of attitude, but 90% of this is literally he does not have the intellectual capacity to understand what the judge is saying. That is what's going on.
Sir, give what you want to say to the jury of the facts within the allegations. That's what we're here for.
The jury is sanctioned by law.
I'm sorry, sir, this isn't a debate. Go into the facts of the case, please.
Okay.
I've made a ruling. Follow the ruling.
I'm being a character witness. Can I call myself as a character witness?
You don't do it that way.
Or
You can speak.
Can I talk about myself?
Yes,
as
you-
a character witness.
The character as to character is not relevant at the guilt or innocence phase. It's at the punishment phase. You can talk about what the facts are and what might have been motivations. I'm helping you out on this. You might have been what motivations that you had in acting within the allegations here. I can't tell you what to say, but character evidence is something that is reserved for the punishment phase, where the jury is to decide what the punishment should be. Right here, it's to determine, did you or did you not commit the offense? Not, are you a good person or not? It's about the facts of whether the allegations have been proven true beyond a reasonable doubt. That's the rule. Please stay within that rule. Go forward.
So the DA can destroy my case.
Go forward, sir. They can ask you questions on cross-examination and you have an opportunity to do redirect statements on your own later. That's the law. You should know that.
For the last 2 days, you've been destroying my character.
Well, sir, that's,
I can't rebuild it.
you should have objected.
I did object. You told me that didn't make it. I did.
Okay, move forward. Move forward, sir. Speak on the facts of the case, sir.
I would like to object to the jury selection,
Overruled. Go to the facts of the case, sir.
but I need to
Sir, it's overruled.
before you.
Sir, it's overruled.
Okay.
You move forward and we'll take,
it on record.
I'm sorry, sir, we'll take that up outside the presence of the jury and you'll have a fair opportunity to make your statement and put the rule on, but not in front of the jury. That's not what's relevant for them. They need to know what the facts are, not what your personal feelings are about this court.
That's-
Move forward.
That's not the way.
Move
objections
forward,
work,
sir.
I have to tell you what my objection is before.
No, I will do it outside the jury. We'll do it outside the presence of the jury. That's not relevant. Go.
They can do it at the jury selection.
No, sir.
To do it.
No, sir, that's not the appropriate way to do
That
it.
is very
We're gonna
much
follow.
the appropriate way, Your Honor.
I've made my ruling. Move forward. Talk about the facts of the case, sir.
I love y'all. Remember, I love y'all. I'll never forget. This is what resilience is. This is what perseverance is. This is what integrity is. All my family that is watching this right now, this is what integrity is. This is what dignity is. This is what perseverance is. You understand me? Don't ever forget this. Don't ever forget this. So, every juror in here is related to an officer in this county. I have a I have a few lawsuits that's naming a lot of officers that did some real foul, atrocious stuff to me throughout these 7 years. The fact that I have a lawsuit pending against this judge right now, and the federal district judge, and they still forcing me to sit in front of a jury that's not my peers, it's completely illegal. It's completely overstepping the Constitution. 3 of the jurors had close relations to Mike Laird by their own admission. One of the jurors was related to the guy that arrested me, to the officer that arrested me and broke my phone and destroyed my evidence. That I had the same officer that I had to prove set me up and framed me at the last trial of a jury that voted in my favor 11-1. Nobody in this country would have voted in my favor. That juror that voted against me was planned, was temporary. I'm still in prison for pointing a gun at somebody. Pointing a gun, which is a misdemeanor. I didn't shoot the gun. I just pointed. By law, that is a misdemeanor. They charged me with aggravated assault. I took probation because I knew nothing about the law. I took probation, I knew nothing about the law. They manipulated the facts. Well, no, they told the truth about the facts on the indictment. But they manipulated the law and said it was aggravated assault by pointing a gun. For 3 years I was on probation, doing good. Mental health probation might not act because I was depressed at the time. I was depressed at the time because I didn't have a job. And I couldn't take care of my kids the way I wanted to. And it was killing me. I was a coward. I was weak around the time because I didn't have the opportunity and the access and research. But after that situation, when I took probation, I was able to get my head together. It ended up getting me a good job. And I was the sole provider in my household, and we was getting good. You understand me? My probation officer, the detective went to talk to my probation officer, trying to see what he can figure out how to violate my probation. You know what my probation officer told him on the paperwork? He's been in compliance for the past 3 years. He pay his fees. He do his community service. He go to work. He don't do drugs. He's been in compliance. I ain't got nothing to give you. So you know what he did? He sent his officers because this one foul female that I was dealing with behind my wife's back, and it backfired in my face. She got mad behind some money. Behind some money that she know I had nothing to do with. Trying to accuse me and want to go to war with me behind some money. And instead of keeping it in the streets like she claimed she wanted to do, she went and lied to them people and told them I raped her. And then she got somebody else that I knew that I didn't know she knew to lie and said the same thing happened to her, but she didn't want to say I did it because she knew I knew too much. We was too cool. That woman, you can tell how bad she was feeling and how stupid she was feeling, sitting up there testifying about something that didn't happen to her. But she was doing it on account of her friend. She was doing it on account of her friend. Because her friend knew that she wasn't going to beat that charge by herself, because I could have proved that every time we had sex, it was consensual. I could have proved it. Text messages, GPS. I could have proved it. She knew she couldn't do it on her own, so she got somebody else to make it seem like, oh, the situations are identical. If it happened to me, I can't be lying because it happened to her too. Trying to make it seem like she didn't know it. But the girl sat up here on the stand and ended up in me. Yeah, I know her. Oh, you know her. But you told the police report you didn't know me or her. And then you told the police you didn't know me or her. But now in here, but when she get on the stand, she said, oh yeah, I know him. We only went on one date. But I mean, it was only one time. First we went on one date. Then we only seen each other three times. Everybody, all these people know. They know I didn't do what I initially was in here for. And they know I didn't do the stuff they trying to give me life in prison for. But they hate me so much. The last 3 trials, this man had a white prosecutor. DA Michael Laird, his prosecutors was white. Miss Angela Mann, been his prosecutor. Angela Mann Nealon, been his prosecutor for a while now. I've never seen nobody else working with him except Angela Mann and Waylon G. Thompson, both of which are white. But here he is on this trial. He got a black woman working with him to try to defeat the appearance of racism. Like I'm not going to acknowledge that. And then it was somebody in the jury box that was related to her. She probably don't even want to be here. Y'all probably gave her some ridiculous offer to help. And she, okay, all right. That sounds like some good money. Oh, that sounds like a good deal. Oh, cool. That's a good deal. Other than that, I'm not understanding why this man just got up here and lied and said he never had interactions with me. Why he just sit there trying to lie and say I dashed the officer with some feces. Why y'all sitting up here blocking my subpoena? I filed a subpoena 3 years ago. I filed a subpoena, and y'all clerks
Some feces?
telling me on this case, filed a subpoena on this case, and y'all clerks sitting up here telling me that I can't file a subpoena, that they can't subpoena nobody for me because they can't do it for me.
That's not an accurate statement.
That is very.
I'm sorry.
I can tell you what day it was.
Sorry, sir. There
I can tell
is.
you what day it was.
Once again, I'm going to tell you when I speak, you must stop, please. That's the rule of law. I know you don't like to follow these things, but that's the rule of law. Subpoenas, if you send subpoenas, first of all, I urge you, have an attorney to help you.
I don't
You
need.
just, I know.
I'm a jurist. I'm an expert.
The subpoenas you've submitted are inaccurate, incorrect, and weren't properly filed. That is why they were not submitted. And I urge you, get some help so you can do it properly. That's why, sir. And not everybody, that's why people go to law school and become.
The defendant should have compulsory process and obtaining witnesses.
As long as it's done correctly.
I don't need a paper motion if
All
I
right.
ask you on
All
record
right.
in the court to do something.
All right, go to what is relevant. That's enough on
Everything I'm
that.
talking
Go to
about
what's
is-
relevant of the allegation of the first degree felony of aggravated assault.
Everything is connected. Y'all only did.
Is there anything else you want to add?
Y'all would have never charged me with this.
Is there anything else you want to add?
If I never filed the habeas corpus, I filed the habeas corpus accusing Joshua Hall, Detective Duchamp, who else? Detective Duchamp, Joshua Hall, Mike Laird, my attorney, of conspiring against me, right? I accused them in a habeas corpus back in 2022, March 9th. Ever since then, I ain't been getting no sleep because y'all want to keep sending people after me in the jailhouse to harass me. And you keep talking about they keeping me in isolation because of my behavior. I was in TDC. I had a job in TDC, doing good. But as soon as I filed a lawsuit, y'all transfer me back down here, throw me directly in isolation. And you trying to talk about my behavior. No, y'all don't have me in isolation because of my behavior. You have me in isolation because of these lawsuits. Matter of fact, I'm about to show the world. You want me to stop? You don't want me to show the world? Hit that button and electrocute me right now.
Sir,
Hit that button and
Sir.
electrocute me right now because the world.
sir, why don't you act properly,
Oh,
sir?
I'm acting very properly.
I don't believe anyone in this room thinks that, sir.
I don't know. I'm still back on the offered electrocution. I think that would tie up these proceedings nicely.
I'm pretty sure they don't because they
No,
were all
sir.
handpicked.
No, sir, this is we're talking about common decency now, sir. The law allows you to speak, but be
Racist
decent.
Peoples versus
Please.
Greg Abbott. Now let me show y'all who name is on the front for it. Whenever you sue a judge or the DA or prosecutor, anytime you sue a government.
Sir, once again, you're charged with aggravated assault. Stay within the bounds. It is not relevant.
Depending on this too, in the federal court
This-
right now,
Sir.
that y'all real messed up about.
Sir, this is an allegation
Right?
of striking somebody about the head and body. Stay within that allegation.
I'm supposed to be sitting in this court. I'm supposed to be dealing with this in the Supreme Court because my habeas corpus is pending in the Supreme Court right now.
Anything else?
Because of
Anything?
this charge.
Is there
Because
anything
of
else
the
you want
charges.
to add?
Retaliation through conspiracy, right?
Is there anything else you want to add?
I'm gonna continue. I'm going.
How long do you expect for this to go on?
It's interrupting me. It's gonna take all day.
No, it won't, sir. If it's not going to be relevant to the facts, I will stop this now.
Well, go
To
ahead.
the facts of the charging instruments, then it ends now. That is enough. It is not relevant anymore.
Retaliation.
That
through
is the
conspiracy. So
end.
everything I'm talking
Is there
about
anything else you want to add about the allegation?
Habeas corpus in the Supreme Court. Now, I sent an emergency motion, letting them know what y'all keep doing to me, how y'all keep harassing. That Lieutenant Tinker body cam played yesterday. He admitted that he refused to feed me, and he thought that was okay. I wasn't aware of it, so it happened, but I wasn't aware of it, so I'm not giving you. I'm not. And
Is
if
there-
it happened again,
Sir.
I will.
Is there anything else you want to add as to the allegation of aggravated assault in this indictment?
I'm talking about what happened.
No, sir,
yesterday.
you're not. You're outside all of that.
What-
And you said that it was going to go on for days. This was not going to happen. If there's nothing else more relevant to if there's nothing else relevant to the allegations of this indictment, you have completed your testimony.
No.
Yes, you have, sir. Stay within the four corners.
Y'all called him to the stand because he was relevant to the case, right?
No, you just don't get to give your life story to the end of time. It needs to be what's
This is not like
relevant.
we're talking about. This is not a life story.
That is all,
This is
sir.
not a story.
You have
It's a story.
completed. You are completed. And I told you about, she can't take, the notes when you are speaking over others. Is there anything else you want to add as to the allegation of aggravated assault? Stay within that.
Yes, it is. It's a lot of.
Stay within that.
All right.
Thank you.
April 22nd, 2021. I was revoked of my.
Hold on, sir, that is 2 years before this event occurred. What does that have to do with what happened on June 6, 2023?
Well, because
Please stay within that event.
I'm still in prison. Like this.
Okay, they know that. They know that. Move on to the next thing. I'm sorry, it's the charge of aggravated assault. Just speak on those facts that happened on or about June 6, 2023, not what happened 2 years or 3 years before in another case. Thank you, sir. Stay within those rules.
It's not retaliation. If you relate, the law say if it's directly related, then
Stay within what happened on June 6th, sir.
Federal Statute 18 USC 1513 subsection E. Whoever knowingly with intent to retaliate take any action harmful to any person for providing to a law enforcement any truthful information relating to the commission of any federal offense shall not be imprisoned more than 10 years or fine or both. That is a federal offense to take any action out of retaliation for providing to a law enforcement any truthful information. Every trial I've been to, I told the truth. I only open my mouth if it's backed up by witnesses or the record. That's the only time I open my mouth. Whoever calls or induce any person, oh, this is Federal Statute 18 USC 1512, subsection B2A. Whoever causes or induce any person to withhold testimony or other object from an official proceeding shall not be imprisoned more than 20 years.
All right, hold on. Again, that is not relevant to this case at all. This is a state jurisdiction case, not a United States jurisdiction. There's the federal government. It has its own sets of rules, ladies and gentlemen. I was a United States attorney for 20 years.
What about
And this is state law that we're dealing with here. Distinct laws. Distinct law.
focus on?
Sir, let me complete the instruction of law to the jury. Please, once again, for the 100th time, don't interrupt when the court's given the law. Thank you. That is not relevant to what the charge is in this case. This is a state jurisdiction case with its own elements. We're not trying a federal crime right here in this
Oh, there will
court.
be no verdict.
That's for the United States District.
Are you new here? There's no happy ending at Law Talk with Mike.
Courts for the United States attorneys to handle. This is state law. It has its own independent set of laws, and this is what we're dealing with, this state law of Texas in this allegation under section 22.02 subpart B, subpart 2, subpart B of the Texas Penal Code. That's distinct from federal law, and your statements on federal law are not related to the relevance in this case. Please confine your statements that you've been allowed to give here within the four corners of this state law brought crime. Thank you for following the law as instructed.
Yes, Ron.
Go ahead.
Mention is the state part, right? If two or more conspire to injure, oppress, or intimidate any person in any state on account of any right or for exercising the same, should not be in prison.
What are you reading from, sir?
This is federal statute.
That is, once again, its own set of rules. This is not what we are. We're not a federal court.
USC.
I know. 20 years I dealt with that, and I dealt with the most serious offense in the United States that was committed. So we are dealing with state law, not the federal law. This is a state law matter, and what you're reading is outside the relevance in this case, and you are denied to be allowed to do that. You can put it on the record later outside the presence of the jury. It's not related to what this jury is going to be deliberating on, and it's the state law violation of aggravated assault. Please stay within the directions of the court and the law. Thank you for doing that. Move forward, please.
Why do y'all hate me so much?
Anything else you want to add, sir? Anything you want to add relevant to the case facts
Yes.
and the law as it's supposed to be followed? Thank you.
Yes. So Lieutenant Ford, right? Let me tell you about the Lieutenant Ford real quick. So when he Lieutenant Ford, when he first wrote this is the first page of his report. Outside of the one.
Yeah, I'm not sure because I never did it. I've got a friend who's a U.S. attorney, but I don't even know the procedure. I think they're all political appointees.
Yesterday, the one we were looking at on the second page. This is the first page. Everybody else report identifies every officer that was there, right? But Lieutenant Ford's report only identified Purdy and Hebert. They wasn't even there. Right. Officer Stevens' report identified everybody that was there. Officer Syndergaard report identified everybody that was there. Officer Darby report identified everybody that was there. Sergeant Anderson's report referenced nobody at all. Lieutenant Ford report only referenced the lady that got these guys to jump me 4.5 years ago and knock my teeth out and reconstruct my teeth the way it is. After she divulged my charges to the dorm and told the people I was a baby rape. And of course they don't believe me because she's an officer. So I wrote a grievance on her and I got 10 people that was in the dorm before I got jumped. Before they knocked my teeth out, I got 10 people to witness what she did. You know what the grievance officer told me? You have no evidence. It's your word against hers and then vice versa. This is not a grievance. Right after that, I got jumped. My teeth got knocked out. Captain Lewis and Captain Minner had to come take pictures of me. I woke up with blood everywhere. I woke up with blood all on my face, all on my clothes. Ever since then, that woman been constantly harassing me. She been constantly harassing me. Now, lately, she been messing with my food. I had to put myself on Johnny set because her and Lieutenant Ford teamed up to convince everybody else all the lies that they've been telling people. So Lieutenant Ford, you know, that was Syndergaard. I forgot to ask him that. Officer Syndergaard, he referred me to Lieutenant Ford before me and Lieutenant Ford had any type of problems.
Okay, this guy was reminding me of something I couldn't remember, but now I do. I alluded to it earlier. Probably everybody has seen this in the last couple days. It's been all over. Chris Rock is doing a thing clowning on Fauci, who deserves it. And where he's pleading the fifth. That's what this guy reminds me of.
Each other. He referred me to Lieutenant Ford as a trustee in the back. Him, Biggers, Officer Jones, what else was that? Officer Jones, Biggers, Officer Washington, the guy who works. Listen, I gave nobody problems in the gym. But as soon as I started filing paperwork trying to go home, that's all I was doing. I wasn't trying to get no money from the state. I wasn't trying to get no money from the government. I don't care whatever mistake y'all made. I don't care how much y'all like me. I don't care what type of crimes y'all committed to get me here. I just want to go home. We had this up. I sent the affidavit. I gave an affidavit to Sergeant Carter and told him to give this to Detective Gardner, Lieutenant Ford, and Sergeant Anderson.
None of this is remotely relevant. He keeps stopping him. I don't know why he's allowing it to go on now.
That affidavit, let them know I swear I will testify to this affidavit. I won't file a lawsuit on nobody. None of y'all. Just dismiss the charge so I can go home. You know what they did?
Yes. Did I say Chris Rock? Yeah, it's Dave Chappelle. I said Chris Rock earlier, but I was referring to his Cracky Tale sketches. This time, yes, it's absolutely Dave Chappelle.
Carter came back. Hey man,
I mean, they're interchangeable to me, and I mean that in the best sense. They're interchangeable to me because they are both hilarious. That sounds insulting. It's not. It's a compliment to both of them.
Hey, I ain't got to know the rap and everything. I told them next time we go over here, and I'm gonna testify to that. They spit in my face. It's in the state. It's in stationary now, man. We ain't got nothing to do with it. So y'all not even gonna go tell the people that I just want to go home. You know, look, it's about arguing. Really? So
Yes. Also, being guilty will help.
I just want to. You gonna keep me here? All right. Let me forget it. Let me see if the lawsuit's worth. Now here we live. 5 months after I filed a lawsuit on a judge for refusing to issue the writ of my habeas corpus, after my attorney admitted to refusing to give me the search warrants, refusing.
Yes. Prince and Rick James were also top notch.
Give me the search warrants to my DNA, my phone, and my car. He admitted. He lied to me. I mean, yeah, I didn't give it to him because he wasn't supposed to ask. I was found not guilty. They charged me with 3 aggravated sexual assaults altogether. I was found not guilty at their first trial. My lawyer told me, if I get this trial, they don't dismiss the other two, you go home. Just don't testify. I got you. I'm like, all right, cool. I say, man, make sure you ask her this. All right. I say, man, what you doing? Ask her the question. I'm going to. He kept on trying to divert the attention the other way, and I had to argue with him at the table just for him to ask her the questions that man, if you don't know this man, how was y'all getting in contact? How is his number in your phone? Under the text-free app? Well, who told you to download the text-free app? My boyfriend. Call his boyfriend and say, sir, did you tell your boyfriend to download the text-free app? No. What about the birthmark that's on your hip? If I don't know you, we ain't never had consensual sex. What about the birthmark? But because you said this happened in the dark. No one ain't see the man's face or nothing. You said this happened in the dark. How could he see a birthmark on your hip if he couldn't see you? He found not guilty at that. They stopped letting me come to court, period, for about 2 years. In the midst of that, charged me with this. Why is Lieutenant Ford all of a sudden coming harassing me like I did something to him? Why? I hated that man because he kept on. Dude next door squirted waste in my tail because I wasn't selling him a pack of cookies. I'm talking about, and yes, like Lieutenant Ford, it was waste everywhere. I'm not about to put it in my own cell. Ford, bro, this retarded, stupid dude. Listen, Levine won't clean out my cell, man. Can you please make Levine clean out my cell and let me go in and take a shower? Or look, matter of fact, just give me some of that bleach and give me a towel and I clean out myself. Man, I ain't trying to die, man. This corona was serious. It was
The irony of this guy using the word retarded.
2022. Corona was serious, still serious. You know what he did? You need to stop arguing with people. You need to stop arguing with people, grievous, man. Wave his hand. Walk off. My heart must have dropped. So you gonna leave me in this? You gonna leave me sitting in another man's waist? Trustee, come through. Trustee, bro, listen. Slide me the mop real quick, bro. Let me get that bleach right there, bro. Just slide me. No, I ain't getting it there. Bro, just give me this mop and okay. Listen, I ain't getting that. You're about to make me lose my job. So I dashed him with water. Water. He go tell Lieutenant Ford. You know, cuff up. Cuff up. So you're not You're not gonna let me explain why I dashed? I don't care. Cause fuck, you explain to me when I take you to your isolation tip. What? You gonna put me in isolation for dashing an inmate? But you gonna leave me sitting in this? No, you're not about to punish me. No, why you doing that, man? You're not about to punish me for dashing an inmate for refusing to give me some chemicals to clean up this waste that you refuse to make the CO do. You're not about to do that. Cause I ain't never did nothing to you. That man can't ask me, did you want to be a trustee? I'm like, yeah, man, I've been trying to be a trustee, man. Come to find out, he only asked me that because Biggers referred me as a trustee. I'm like, oh, that's why he can. Because Biggers let me know, yeah, man. I told him, man, only person back here competent to be a trustee. You know what I'm saying? You don't give me no problem. I'm like, why he ain't named a trustee yet? Because he can't ask me. You know what I'm saying? All right, don't worry about it. Then next thing I know, I had this little situation with the dude squirting away from myself. He ready to ride down on him. He ain't trying to do no talking, cuff up, or I'm coming there and get you. What? Really? You ain't gonna clean up this waste, but you gonna come in here? Oh, you gonna come in here to hurt me, but you ain't gonna clean up. All right. Come on, let's fight me. Because I'm not cuffing up. Now I'm not about to cuff up for you to hurt. Now I cuff up for you to clean this white cell out. And then you can write me up if you want me to, and block my privileges. But you're not about to come in here and put me in an isolation cell after refusing to clean out this net. So then, Lieutenant Ford, after he do all that, after he run down on me, after I get done dashing him with the water, not waste. Even then, even him leaving me in somebody else's waste, I still didn't have the mentality to stick my hand in the toilet being in another man's waste. I was throwing up. So I can't touch my own. Let's go. Somebody else's. I'm in there gagging because he don't want to clean the cell out. So I started dashing him too because he wanted to punish me. Yeah. He get me to the isolation cell, right? But man, this day I didn't swing at nobody. I didn't threaten to stab nobody. You know what I'm saying? He get me to the isolation cell. I had all my paperwork, all my legal work, my legal books, my kids' pictures I would never get back. Pictures I would never get back. He threw all my shit. Threw all my stuff away. He threw all my paperwork that way. All my books that my sister bought me, all my legal books. My checks cold. I couldn't even file a motion with the Supreme Court. My prisoner discharge motion with the Texas Supreme Court of Criminal Appeals because he had to throw all my stuff away. You know what I'm saying? I wrote a grievance about it. For my whole month, I'm steady begging my stuff back. I'm letting them know, look, man, I'm sorry, I will give y'all no problem, man. I clean this stuff up with some jail soap next time. I ain't tripping. Just give my stuff back. I'm begging for I never seen my stuff again. He threw all my stuff away. Or he gave it away. One of the two. I don't know. It's a lot. You know what I'm saying? I keep a lot. I had a lot of paperwork. I keep a lot of paperwork because I'm always either writing my kids, studying the law. I'm taking notes, doing what I need to get back to my kids. Threw it all away. I'm like, all right, cool. So I see what type of time you on. You know what I'm saying? You trying to shield me, and you trying to keep me in prison. Okay, cool. Let me stay out this man's way. He ain't playing no game. Let me stay out this man's way. He came back a couple months later, came back to that same cell we put me in. Hey, you want to move the indoor? No, I don't. I'm not leaving out this cell. Because this cell I'm protected in. It's a camera right there. They can see everything. I'm not leaving out this cell. Y'all not. They're like, what about indoor? Now, man, this is Lieutenant Ford I'm talking about. What about indoor? You want to move to indoor? No, I'm good. I'm not leaving the isolation cell. I'm protected. Can't nobody throw no waste in my cell. Nothing. You can't take my paperwork without it being seen. Nothing. Right? But then he had somebody else try to come. He had a couple other people trying to convince me to leave the cell because he needed it. Oh, I don't care what you need. I need this cell. You go home. I need this cell. Hey, I'm not about to put myself in a situation where somebody else can do what you did. Turn around. This man back door. Wake me up. Hey man, we gotta do maintenance in the cell. So pack your stuff and move in the ISO 1. Mind you, I was going to the day room. When I go to the day room, they let me go to the run day room, right? Because I don't cause problems. All the other inmates back there, they gotta cuff up and go to the day room out back in isolation. In isolation, you gotta keep the cuffs on. But because I never gave the officers problem, they will always let me go to the day room on the run, put me in the cage, take my cuffs off, so I can take me a shower, so I can do my legal work, so I can talk on the phone when I want. You know what I'm saying? You can't do that in the isolation hallway like that. You know what I'm saying? You can't watch TV like you want in the isolation hallway. They let me go to the run, so every time I go to the run, I gotta pass up all the cells, right? On my way to the run, the day room the night before, it was a mentally deficient dude. He really had a real bad mental illness. He played with his waist all the time.
Mr. Peoples, hold on. Do you have much more to go on because it's into the lunch hour? This jury has been in here for a long time. Do you have much more to say?
He said, talk about the case. I'm telling
Do you have much more to say is the
Yes,
question.
yes.
Then we're going to break for lunch. Can all of you return back at 2:00, ladies and gentlemen? 2:00. Thank you. Please remember the instructions the court has given to you. Thank you. We're in recess. Okay, Mr. Peebles, just sit up here. We'll put you right back where you were. We'll pick up where we left off. All right, stay ready.
Yes, sir.
Defense ready. Bring the jury in. And the jury is seated in the courtroom. All parties are present. When we rested last, the defense was making his statement in his case in chief. You may pick up, sir.
So, never caused no problems. Isolate, not this time in isolation, but time where 3 years ago when they charged me with this charge, right? Never caused no problems in isolation, so all the COs would let me go to the day room in the cage on the run. The videos, the pictures that y'all seen, where they took me and put me in a wrap, that's the day room on the run. They can take the cuffs off you and let you work on the computer, talk on the phone, watch the TV, take a shower, right? In isolation, your movement is very limited and whatnot. But I would refuse to go back to the run because it was too many people playing with waste, too many officers that on a regular basis that like to take my paperwork. It happened actually 2 times. So after the second time, I wouldn't go back to the run. I just go to the run to go to the day room. So when I passed by the cell the night before Ford came to have fun with me, when I passed by that cell, I seen dude. It was streaks of his waist smeared on the window.
We've been going a little less than 3 hours, and there's maybe 2 hours and 15 minutes left.
He even had it on his body. When I came back, he was still in there. After my hour day room, they put me in that back in my cell, isolation cell
Brecken put it together, so I'm guessing it ends with a Rickroll.
6. A couple of hours later, he got moved to infirmary ISO. Nobody ever came clean that cell. I was up practically all night. Nobody ever came clean that cell. That morning, when Ford came woke me up, it was around 7 or 8 o'clock. I'm letting them know that I just need somebody to clean the cell out because they moved that dude last night. I need somebody to clean the cell out. All he kept saying is it's already been cleaned. It was clean last night. I say, no, it wasn't. No, it wasn't. Can you please have somebody clean it up? No, it wasn't. He insisted that it was clean last night. He telling the other officers. Even Stevens, I'm telling Stevens, bro, can you please just go clean the cell out, man? He said it was already cleaned out, man. We just need you to go in there. So when I told Darby just actually finally decided to go down there himself and clean and look, check. When he got back, he said, yeah, I see what you're talking about, man. But listen, once you get in there, I'm gonna make sure you get some, I'm gonna give you chemicals. Once you get in there and we take stuff out, I'm gonna make sure I give you chemicals and a mop and such. I say, nah. Last time he wouldn't let Levine give me that stuff. I don't trust him to do that. Just listen. When he walk out, just go down there, sleep down there, and throw it in the cell for him. Just throw it in the cell. He said, look, man, just come on, man, stop giving us a hard time, man. Just, no. Why is y'all thinking that is okay? It's not okay. Now, all 3 of those officers sat in his chair and told y'all the same. They all told y'all that I was complaining about this cell being nasty and wanted it to clean up at that very moment, which means everybody had knowledge of my contentions about moving that cell without it being clean, right? So that was a simple fix. Throw the chemicals in there in the mop, in a rag or something, and I'll do it myself. He wouldn't even let them do that. And they kept trying to make excuses for me to just chill and do what he's telling me. Now, if everybody had that knowledge, why is they only taking pictures of isolation cell 6? Okay, everybody know I'm in isolation cell 6. Why do you need pictures for isolation cell 6? Why are you not taking pictures of isolation cell 1? Why is everybody hiding the evidence of them trying to indirectly kill me and trying to make it seem like I'm some type of thrown off, chaotic person? I haven't done nothing to nobody in this jail for them to be doing it, which means somebody got to be sinning.
I'll give these guys credit. If their conspiracy was to make this guy look like a stupid criminal, they have succeeded. I mean, completely.
Talking about one after another. Where this come from? I ain't never had no problems with Tinker. Why he did that? Yesterday, when I got back to the jail from this courtroom, I've been, like I said, this is my 4th trial. I came to the hearings plenty of time. They ain't never searched me coming back from court. They have searched me going to court, and they never searched me coming back from court because there's no need to. Right? Like, yeah, when I get back from court, Lieutenant Davalos and Sergeant Hawkins made me strip out butt naked, squat and cough while the cameras was going. And they stood a distance so the camera can see my whole body. I'm asking them, what is this? Is this to make me, what? So somebody told y'all to record this so they can have some fun afterwards? Why y'all got y'all recorders on? Y'all ain't never made a person strip out while recording. And why is it taking a rank to do this? The officer, I ain't never been strip searched by no ranking officer. It's always a regular CO that'll strip search me. Why is it 2 ranking officers with their cameras on
standing just 3 feet away from me, enough for it to see my body. They got their heads turned like they don't want to see me. Somebody had to send them to do that. Right after I left court, yesterday. Humiliating me. For what? Because Ford told him to? Because Ford admitted that I didn't stab him? Because they know the jury gonna find me guilty regardless, no matter what I say, and it won't add up.
Anything else?
Yes.
Please get to the end, sir. Thank you. And again, stay within the 4 corners of the allegations. I've said that. That's what we're here for.
Land the plane, a-hole.
Whether or not you have committed this crime of the first degree.
Talking about Ford.
Sir, let me complete my sentence, please. She's counted up how many times you have interrupted the court during this hearing, and it's numerous times. Let me speak, and you have a fair opportunity to be heard. Stay within the 4 corners. That's what's relevant.
All right.
4 corners of the accusation. Thank you for following the rule. Go ahead.
So, I'm gonna find it right now. But well, the habeas corpus to this case, November 15th, sent the habeas.
Ma'am, are you a whore?
It was filed in December or whatnot. The habeas corpus was explaining how Lieutenant Ford's statement admitted that I didn't stab him. And I also explained why I was combative, which made that charge completely illegal, right? In America, right? In this country, when an indictment isn't in the 4 corners of the allegation, right? That is, there we go. There's grounds for dismissal and to produce the body. That was like they wouldn't even give me a hearing for it. Right? The habeas corpus. The habeas corpus is that thing that Donald Trump wants so much to abolish because of situations like this.
No, I'm sorry, sir. You're misleading the jury. Habeas corpus, he is getting his time at trial. He wants his time at trial under the Constitution. That is his habeas corpus hearing right here, essentially, but with you and the jury. It was indicted. I don't make the decision on indictments. He didn't come to the judge for the determination of guilt or innocence. He has insisted on a jury trial, and with this being the 617th jury trial, we're trying as much as we can, as fast as we can, ladies and gentlemen. But under the law, this is what equivocates to a habeas corpus proceeding. This is the trial by jury. He has been insisting. He has it, and that is irrelevant. You can move forward. This is your time to be heard, sir. So
Why are you unnecessarily wasting the judicial time of this court?
I'm allowing that in spite of the difficulties here. Please proceed and move forward. Thank you.
Your Honor, I would like you to issue the writ of my habeas corpus. My pretrial habeas corpus for this charge.
Okay. That is denied because it is not presented in the correct way under law. That's why I've asked you, please work with an attorney if they help you do it correctly. And when you insist on representing yourself, you have to follow the rules like all others. And the court is the person who makes the ruling like a basketball official on the court.
Article 1148, written issue not necessary. It shall not be necessary on the trial of any cause arising under the habeas corpus to make up a written issue, though it may be done by the applicant for the writ. He may accept to the sufficiency of or controvert the return or any part thereof or allege any new matter
Okay.
and avoid it.
Sir, I'm going to present the law that's necessary for the deliberations. A writ of habeas corpus does not substitute for a trial by jury, ladies and gentlemen. This is what he has asked for. He's getting the trial by jury. An application for a writ and a writ hearing is a separate, completely different sort of circumstances. This is what the Constitution allows, a trial by jury, and we've got him here as soon as we were able to get him in the queue with our trial backlog that we have in this county, but we can only try one at a time.
All persons is innocent until proven guilty.
No, sir, that's incorrect. The jury knows that.
My bad. All persons are innocent unless.
There you go.
proven guilty.
Good for me.
Right. So at my probation hearing, when you said based on the scientific.
No, sir, we're not getting into the probation hearing, sir. I'm sorry.
I sentenced you to 20 years.
All right. That, you keep interrupting the court, you will be placed outside.
I was talking.
We're going to have right now, the jury is going to be excused. This is a trial about the allegations of this indictment, and you have to stay within the allegations of the indictment, sir. We're not. And also, I have instructed you about interrupting the court so I can make a ruling with the court reporter. When you keep interrupting, I am unable to do my job. I've asked you not to do that. You keep continuing to do that.
I was talking to Ms. Bradley. I didn't talk about.
You were speaking about something that had nothing to do with this trial, sir. The next time you interrupt, you will be placed in a holding cell. We will have the trial for you to listen to. That's the way the rules say it happens when you keep interfering with the rules of decorum. Do you understand what will happen? Please follow those rules, Mr. Peebles. I want you to get what you want said, but if you keep interrupting and not following the rules, I don't have any choice but to change the circumstances. And you are the only one in this room who keeps not following the rules. Please follow the rules, and you have a chance to be heard and stay relevant to the allegations in this indictment. Do you understand, sir? We're in short recess.
Like to continue, Your Honor, or like to request to continue.
No, that's denied. We're going to complete this trial.
You know what? No.
Holy wow. That's retro.
Let's see if it's different like that.
Court is going to make some findings here that the defendant is intentionally prolonging these proceedings by refusing to follow the instructions of the court, by bringing forth statements and thoughts from matters that are irrelevant to the four corners of this indictment. He has been instructed numerous times to follow the rules. He continues to disobey the rules. He continues most often to interrupt the court when the court is making its rulings and findings on the record, which prevents this court from doing its job. And I've warned the defendant, if he keeps that up, we have no choice but to put him in a different room where he can listen and watch the proceedings without interrupting them. We'll see what happens. This has been consistent in this trial and railing on about matters that have nothing to do with the four corners of the charge is obviously an attempt to prevent this trial from ever ending.
Yeah, I haven't.
And the court has a duty to
Any other case besides this?
move forward on a trial in an expedient way that's fair to all. And he's preventing that from occurring. All right, let's bring him out.
I got this one taken care of, and I took care of the first one, just Dollinger. I did that, for the last 30 minutes, I got more done in 30 minutes than I have in all day.
All right, let's get the jury in, please. Thank you, Kendall.
Always fight for what you done. You know?
Sir, do not speak except to answer the questions while the jury is here. Don't be making statements in front of the jury, sir, that aren't part of the question and answers. Reverend, just show the jury is seated. Thank you, ladies and gentlemen, for your attention and your patience. All right. Mr. Peebles, you may go forward. Be mindful of staying within the relevancy of the four corners of this indictment as it is alleged. Thank you. You may proceed.
Lieutenant Ford, I was cussing him out one day, and he said to me, you must love living the truth. I said, no, I'd rather die on my feet than to live on my back. He said, that's so she could, he tell me like that, that statement is so cliche. Okay. That's because you used to doing people like me the way you do them. Something like that means nothing. I told him it means a lot to my kids, though. And I'm gonna make sure my kids understand to always fight for what you love. That's what I told him. I said, man, listen, I would not be a good role model if I gave up on my kids. So, you know what he had to start doing? He started having people tamper with my mail, blocking their access to the courts. Once they bid for me, I'll be out at June 25th, 25. I had wrote a complaint on the federal judge about allowing Judge Stevens to keep me in prison in violation of the habeas corpus proceeding. 3 weeks later, he had me bench warrant out here. 12 months ago. 3 weeks later, he had me bench warrant out here. Threw me directly into an isolation cell, blocked my communication about 5 months. And the whole time, Lieutenant Ford would cut my water on periodically, and I would have to argue and trip out about it just to get it cut back on. And that complaint was on a judge for him refusing to rule on my habeas corpus.
Wait, hold on. So the jury is clear. Are you saying that I ordered sanctions against you in the jail? Is that what you're telling this jury? Is that what you're telling this jury, sir? Under oath.
I'm telling the jury that Lieutenant Ford is able to be doing the stuff that he's doing to me the past 12 months because I wrote a complaint on a federal judge for refusing to rule on my habeas corpus which was complaining on you. And 2 days later, he ruled on it, but I was bench warrant out here. He ruled on it July 16, 2025. I was bench warrant out here July 18, 2025. But June is when I wrote that complaint that sent it off. Which means it took about a week to get to the court, which means it only took 2 weeks for me to get bench warrant out here. Through an isolation cell after he denied my relief.
The federal, you're telling the jury that the federal judge denied the relief you were requesting, correct?
Right. And
Okay.
he bench warrant me out here.
All right,
I mean,
move forward.
that's the only way I can be bench warrant out here. How did you know he denied my relief? Just 2 days before he bench warrant me out here. And when I get out here, y'all put me directly in the isolation center. TDC. I wasn't in the isolation center. I had been in TDC for like almost 2 years. But as soon as I filed a lawsuit a few months before and a complaint a few weeks before, I get bench warrant out here and harassed at an extreme rate for 12 months by Lieutenant Ford and his co-conspirators. I sent off an appeal for that habeas corpus. August 6th, it was filed August 14th. In that appeal was my certificate of appealability. I had Sergeant Knott walk me to the lieutenant's office to call the court because I couldn't use my own phone because they were blocking. So he walked me to the lieutenant's office. Mind you, they will only do that if you don't cause, if you're not a problem. So he walked me to the lieutenant's office and he let me call the court. I called the court and I asked them, did they get my notice of appeal and my certificate of appealability along with my emergency. They say no, all we got is the notice of appeal. It was under review for jurisdiction. They know, which means all of that went in the same letter. It was in the same envelope. So for my notice of appeal to only be there, and then my certificate was identified on that notice of appeal. But my notice of appeal not filed. Not notice of appeal. My certificate of appealability was identified on that notice of appeal. So for my certificate of appealability to not make it, will only have to mean somebody at the jail took it out of my envelope before it got there, or the clerk had it simply was not bothered and throw it away. Sergeant Knott camera was going at the time when I called. And my anxiety went crazy. After that, they denied. I had to send off another certificate of appealability. And I started giving my envelope directly to the COs. For them to give it directly to the mail agent to get off the unit. And write their name and the time and the date on the envelope. Just to make sure it got off the facility. When I sent my other certificate of appealability, they end up denying it. Turned around, I sent the emergency motion for reconsideration. I called court on the 9th. The 9th of January. My certificate was denied on the 30th of December, which makes the deadline would have been the 14th of January. I called on the 9th to make sure they made it. And they said, I called on the 9th to make sure whether or not they ruled on my certificate. They said my certificate was denied on the 30th of December. So I sent off my motion for reconsideration on a 12. When you're in prison or any type of institution, the day you file a motion, the day you put your motion in a penal institution facility is considered filed. But they told me I was on time because they ain't getting into the 20. Throughout this country, in every state, the rule is the day the inmate places his motion in a penal institution mailing system, it is considered filed in the court. But they refuse to follow with the panel. For them to do that, a judge having allowed them to do that. So they wouldn't address the issue of this charge and all the other charges. So after that, I filed a habeas corpus with the Supreme Court. The Supreme Court will not file your habeas corpus if you don't do it right and if it is not in good faith. But yet they filed it. They docketed it. And one of the justices denied it. I didn't know they went this far. I thought I was safe in the Supreme Court. But the fact that I sent off an emergency petition for rehearing June 9th, and I'm sitting in this courtroom witnessing what just took place the past 2 days, especially at the jury selection, I know that it must be people in the Supreme Court allowing them to do this because they will not let me go to this trial no other way. But then when I do get to the trial, they violating every right in the Constitution. Every single right, especially the 6th Amendment. And I want everybody to know this. Even if you give me life in prison, that will not provoke me to hurt myself or nobody else. I'm gonna make sure my kids understand resilience, perseverance, integrity, dignity, honor, decor. It's very important. Never let nobody take that away from you. I'm done.
Hold on. He has a right under the Constitution for cross-examination, sir. Did you want to ask any
No,
questions?
I don't need to talk to him.
Okay, you're excused. All right, anything else, Mr. Peebles? Do you rest? I take it from your silence, you're resting your case. Anything, redirect from the state?
No, Your Honor.
All right, ladies and gentlemen, we're going to take a short break here. The court is going to finalize the jury instructions that we've been working on, and we can't finalize them until the parties have rested. And then we'll bring you in and go over the charge, and then the parties can make their final arguments to you. You'll go into the Thank you. That's our plan. Thank you. Everyone else remains seated while the jury exits.
Behavior in this case is disgusting.
Is exiting. The court has provided the parties with a jury instructions. We're going to go over these. Mr. Peebles, make sure that these are in order. Members of the jury introduction. The court will note that the defendant has pushed aside the jury instructions and is refusing to review them. And the court will also note that when I asked the defendant if he had completed his presentation of his case, he refused to answer. Then second is definitions page, then assault, aggravated assault with deadly weapon against a public servant, bodily injury, serious bodily injury, public servant definition, correctional facility, deadly weapon, intentionally, knowingly, recklessly, jury charge, general instructions, 3 pages. 2 verdict forms. We, the jury, find the defendant guilty. We, the jury, find the defendant not guilty. The state, any,
Judge, there's an issue back when you got the definition of assault, and the next one says assault on a public servant. That's not the correct definition of assault on a public servant. Aggravated assault on a public servant, it's just an aggravated assault.
stand by. Well, to B is section 20, it's under section 22.02 called aggravated assault.
No, it's under,
That's the way
it is, but it's.
That's the way it was indicted, folks.
It's not, no, but there's more to it than to be a public servant, not an aggravated assault. See, you got it.
No, I know it's called, but it's called aggravated assault. It's under section 22.02, which is aggravated assault. It's a form of aggravated assault.
I understand that, Judge, but you put aggravated assault of a public servant, and nowhere in that definition does it have public servant of a public servant in the performance of his duty, which is what it's supposed to have. Is this 2A or let's see, 2A, 2B,
B2B.
yes.
Oh, good
All right.
Lord. Now I feel like I'm at work.
Under assault, aggravated assault with deadly weapon against a public servant. And I think this is the right definition here. A person commits the offense of aggravated assault. If he commits assault against a person the actor knows is a public servant lawfully discharging an official duty. Okay. It's a person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. All right. What other changes?
No other changes.
Anything, Mr. Peebles, you want to change on these instructions?
Wish I can change the word.
I wish I could change the world, what his statement is. All right. Please make this change. Otherwise, any other objections by the parties?
No, Your Honor.
All right. We'll make this change, bring the jury back and read the charge, and then the parties can make the final arguments. Record shall now show that all parties are present and the jury is present. Anything to bring up further by the party, state?
No, Your Honor.
And Mr. Peebles on defense. Anything further? There's no answer. Earlier I asked and Mr. Peebles said, I wish I could change the world. So I'm going to move forward here. And at this time, the court will read to you the jury charge of the court, which contains the law applicable to this case. Ladies and gentlemen, and continue.
If you know what I'm talking about, you're old.
Continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will when I read this charge to you. It will be left with you to refer to as necessary during your deliberations, ladies and gentlemen. Members of the jury, The defendant stands charged by indictment with the offense of aggravated assault against a public servant alleged to have been committed in Jefferson County, Texas, on or about June 6, 2023. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and terms used in the charge, the law provides the following definitions. Assault. A person commits the offense of assault if he intentionally or knowingly or recklessly causes bodily injury to another. Aggravated assault with deadly weapon against a public servant. A person commits the offense of aggravated assault if he commits assault against a person the actor knows is a public servant while lawfully discharging an official duty. Bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Public servant. Public servant means a person elected, selected, appointed, employed, or otherwise designated as an officer, employee, or agent of the government, even if he has not yet qualified for office or assumed his or her duties. Correctional facility. Correctional facility means a place designated by law for the confinement of a person arrested for, charged with, or convicted of a criminal offense. The term includes a confinement facility operated by the Texas Department of Criminal Justice. Deadly weapon. Deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Intentionally. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. Knowingly. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Recklessly. A person acts recklessly or is reckless with respect to a result of his conduct when he is aware of but consciously disregards a substantial and unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the defendant's standpoint. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about June 6, 2023, the defendant Raymond Peoples did then and there intentionally, knowingly, or recklessly cause bodily injury to Charles Ford by striking Charles Ford about the head or body with pens, and the defendant did then and there use or exhibit a deadly weapon, namely pens, that in the manner of its use or intended use is capable of causing serious bodily injury or death during the commission of said assault. And the defendant did then and there know that the said Charles Ford was a public servant, namely a Jefferson County Corrections officer in the lawful discharge of an official duty, to wit, transporting said defendant with the correctional facility. You shall find the defendant guilty of the offense of aggravated assault against public servant. Stand by. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are in this case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror nor consider it themselves and arriving at a verdict. Questions and comments of the attorneys or parties, if they represent themselves, do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys or the defendant representing himself that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson, and then be given to the bailiff. The question will then be answered by the court as soon as possible, to the extent allowed by the law. Any physical exhibits which have been admitted into evidence will be furnished to you by the bailiff upon your request. After the attorneys and the defendant present their arguments to you, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision or decisions, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. There are two options you have. One, we the jury find the defendant guilty of the offense of aggravated assault against public servant as charged in the indictment, placed for the foreperson to sign. Your other option, we the jury find the defendant not guilty of the offense of aggravated assault against public servant as charged in the indictment, a place for the foreperson to sign. Of course, only one jury form can be signed. Under the rules, the state of Texas may open and close final arguments. What says the state?
State of waive its right to open, reserve its right to close, Your Honor.
Okay. The state has waived its opening. Mr. Peebles, you can move forward and give your final argument now.
During the video, during examination of the video yesterday, You all seen and witnessed that when I exited the cell, I never swung or struck anybody with those pins. Even more so, what's the name? Sergeant Anderson blatantly said I struck Lieutenant Ford with the pins after Lieutenant Ford admitted that his injury came from my fingernail. You also heard the testimony of everybody that say they don't remember seeing me strike Lieutenant Ford at all with the pins. 5 people was there. Only one person said that. 4 people is not gonna mistakenly miss something so explicit, especially the way it was strapped to my hand. Clearly,
Especially.
I was doing what I was doing to deter his actions and discourage the constant harassment. Clearly, that didn't work. So, being that didn't work, I obviously had no intentions on stabbing him. When I grabbed his face, I could have gouged out his eyeballs. I didn't do that. Clearly, my intentions wasn't malicious. I just simply wanted the cell cleaned, which by law, that's cruel and unusual punishment to force somebody amongst something like that. But yet, everybody, exhibit 1, 2, no, I forgot which one it was. But after I showed, what's his name, Detective Gardner, his report, he said he did write this or whatnot. And one of the papers is he stated in his report, Lieutenant Ford indicated in his report that Peoples exited the cell holding a pen in each, and holding the ink pen in a manner to use as a deadly weapon, but he believed the visible injuries he received come from Peoples' fingernail. His aggression was focused on Lieutenant Ford as he used the ink pens to cause several lacerations on Lieutenant Ford's face, neck, and upper chest. Several of the wounds were close to Lieutenant Ford's right eye and could have resulted in more serious bodily injury. So, regardless on how they manipulate the law on the instructions, the indictment is clearly stating that I stabbed him. His probable cause affidavit is clearly stating that I stabbed him. His report explicitly demonstrates that I stabbed him. The indictments express that I threatened with imminent bodily injury, which would be force of a violent nature, right? Which would be assault.
That covers it right there.
Not aggravated assault. Aggravated makes it becomes aggravated when you use a weapon. Simple as that. Or cause serious bodily injury. One of the two. Use, not just exhibit a weapon, not just hold a weapon. When you exhibiting that weapon, you have to actually use it. Which means if you have a knife in your hand and you cut somebody, that's using it. If you have a gun in your hand and you shoot somebody, that's exhibiting it while causing serious bodily injury if that bullet hits them. Exhibiting it is merely a description of a remote
I don't get the distinction he's trying to make here. What's the difference between use and exhibiting in this deluded world?
A remote injury. That's it. A threat to cause death or serious bodily injury by the production of a weapon or otherwise, as long as the actor purpose is limited to creating the apprehension that he will use force if necessary, does not constitute deadly force, which would be aggravated assault. Penal Code 9.04. Texas Penal Code 9.04 is what that
Sorry, I'm
was.
gonna have to object. He's stating law that's not in the charge and is not before the jury.
All right, the objection is sustained. Ladies and gentlemen, you can only consider what is within the jury charge and the law that the court has given to you. That is what the law states. It's in the judge's domain, the law to be given to you based upon the law. The parties are not allowed to supplement the law during final arguments, or to change indictments or to change the laws. So your objection is sustained. Move forward, sir. Thank you.
A person commits an offense if he recklessly engages in conduct that places another in imminent danger of serious bodily injury. The production.
Oh yes, it's getting serious over here. We are into the Cherry Garcia portion of the evening.
Reckless and danger are presumed if the actor knowingly pointed a firearm in the direction of another or not, whether the actor know or not. That's what I have 20 years for.
I'm sorry. Once again, if two people speak over each other, when an objection is made, Mr. People, you have to stop. You will have an opportunity to complete what you need to say for the record. The objection is sustained. Did you want to add anything else, sir?
Yes.
Okay.
So I want you guys to be aware that so the day that the judge violated my probation, he gave me 20 years for the aggravated sexual assaults or whatnot, and then I went to trial afterwards and found and it was found not guilty.
Hold on. Yeah,
I want you to understand
Sir,
that
hold
was
on.
double jeopardy.
Hold on, sir. Hold on, sir. So the jury understands this court doesn't violate anybody's. I'm not violating anybody's probation. If someone is on probation, a motion to revoke probation is filed by the executive branch of government. It's not a jury trial. A motion to revoke probation gets heard strictly, exclusively by the judge, and the judge makes its determination based upon whether it's a preponderance of the evidence standard or beyond a reasonable doubt, based upon the circumstances. But just so that you understand, so that you're not confused, this court doesn't violate anyone. And in the way that term is used properly in English. But if someone is on probation and violates probation and there's a hearing and the court finds that enough hearing supports the allegation of violation, then the court can grant the motion to revoke probation, then find.
All right, this is why I'm not on the bench, because I would step into it. I'd be like, I just want to make the record clear that this court is all about violating everybody all the time.
The defendant guilty, and then the court has the authority to set a sentence based upon additional information that the court may receive for sentencing. That is the way that works. But once again, just so that you're not misunderstanding, this court doesn't violate a human being. I don't violate people. That's misuse, and I don't want you to misunderstand. But a person on probation, if they violate the terms of probation, not me, but if a defendant does, by proof, then the court can revoke probation and sentence a defendant. That's the way that works in motions and revocations of probation.
Keep in mind,
This is not a
I'm almost done with
revocation of
number two.
probation here. This is
But does it count? I had one and maybe a quarter, and then I had ice cream in between. It's not very diligent drinking.
indictment separately alleging what you've heard throughout this case and what was read to you and what the court instructed you on under its instructions. All right, Mr. Peoples, you may go forward.
And yes, the judge is right. A court may violate a person if they're on probation or whatnot, if they have jurisdiction of that charge that they're violating that person on. But if they never had jurisdiction in the first place and that charge wasn't supposed to be in their court, they was never allowed to violate. It wasn't sanctioned. That act wasn't sanctioned by law at all. Actually, that's an understatement. They never had any legal right, period. No power to violate that probation. Correct, Judge? Is that correct? Is that right?
I believe the jury is making a determination on the indictment, sir.
Right.
The probation, any probations are not part of this case. Please strictly stand by what's been charged so that the jury is not confused. Thank you.
So
let's stay with the indictment and the proof for this indictment. Thank you, sir.
On this indictment, they plan on giving me 15 years to life because of my prior conviction, which the judge never had authority to convict me on in the first place. Is that correct, Your Honor?
You're asking me a question, sir?
Yes.
No, move forward.
Yeah, first of all, it's not time to ask the judge a question. Absolutely inappropriate. Second of all, it's wrong. It's fundamentally wrong on every level. And you're sitting here looking for a backup for me? You got to be kidding.
This court has not been reversed in your cases. No, the decisions made in your cases have been final and approved and affirmed. Move forward with this argument. Thank you, sir.
I was just asking, was my interpretation right of the indictment that I have now?
We're talking about the indictment. There is a presumption of innocence, and I wrote the lead article in the state and law on the presumption. That's sacred. The presumption of his innocence exists unless the jury decides proof has been proven beyond a reasonable doubt otherwise. That's the rule of law. Go forward. Thank you.
Well, with two of those charges being one being dismissed and the other one being found not guilty, I will be being held without indictment, right? The fact that I'm doing 20 years in prison for those violations, for those sexual assaults, will mean I will be getting held without indictment, seeing that two of them don't exist anymore. Correct?
Your Honor, I'm going to object. If Mr. People stick to arguing this case, he can do his appellate work with the appellate court, which he's already done.
All right. So
those rulings have already been sustained by appellate courts. Let's move forward on this case. Thank you.
All right. Witness against. Right. Anytime a witness themselves, the witness themselves, right? Not a prospective witness, but the witness themselves, the victim, admits to the contrary of the indictment. I mean, the Sixth Amendment would be getting violated when it says the accused shall be confronted by the witnesses against him. So if the court says that the jury is bound by the law, right? You know, for the love of God, right? By law, I'm not supposed to be convicted of this crime.
The face palm is so good.
Correct, Judge? Or did I
You don't
like
ask the court questions during final argument. You know that, sir.
Oh, I
make your.
No, he doesn't. He just says the dumbest, absolutely 100% wrong thing. Again, this is the second time, and then ask the judge if he's right.
Final argument.
I just thought you were going to.
Thank you, sir.
So the implements for an escape. The fact that the detective himself wrote that on one of his reports that the victim believes that he was scratched. And then on the other one, he admitting that I told him I had no intent, nor do he have any evidence of any intent to escape, right? It makes that those two factors also makes both of these indictments illegal. So, you know, that's pretty much all I got to say about this. And and also the law says whoever knowingly have knowledge, whatever officer knowingly have knowledge of the illegal confinement of the person that they have detained shall issue the writ without delay. Code of Criminal Procedures 11.15.
Code of Criminal Procedure.
And it is his duty to issue the writ without delay. That's 11.05.
Which is
Penal
number
Code-
one, wrong.
Criminal Procedures 2.03. The state, the prosecutor, the judge, and the attorney representing the defendant, with all attorneys, all court officers, shall conduct themselves to find to seek justice, not impair the ability.
Shall conduct themselves. It's so painful. It's so painful.
Of the accused to prove his innocence. 2.03 Code of Criminal Procedures. I'm done.
All right, statement close.
Y'all for your patience this last few days. I hope you could appreciate the tightrope I've been walking, trying not to overdo that lawyer stuff and trying to help Mr. Peoples when I can. But there comes a time when we got to look and say, you know, all this stuff that he's been doing, he's already done in appellate courts and everything else, and they've all denied him. And so he's just he doesn't get his way. And so he keeps saying it over and over, just like he did with the lieutenant, hoping he'll get a tray. And I get tired of it because what he did that day on June 6th of 2023 was a violent act. And you cannot deny that, because if you deny it, then you have to say, I don't recognize the fact that he wrapped his hands in cloth, getting ready for battle with pins in them, and came out of that cell with his mattress out in front of him. Why did he wrap his hands with cloth and put pins in them? And why was he coming out of the cell with those if he wasn't intending to harm anyone? Second, you heard Lieutenant Ford say in his testimony that when Mr. Peoples reached for his face, lunged at him, which you've heard a couple of them say, lunged at him with his hands, he still had those pins in his hands and all he felt was pain. And yes, there's some scratches on there, but you also see that little sharp one. And that's where Arliss Anderson saw, standing right next to where Lieutenant Ford was struggling with this man, who all he had to do was say, I'll go down to the other cell. And he had a chance with Mr. Darby up here on the stand. You remember Mr. Darby walked all the way down to that cell and stuck his head in there, was in there for 30, 40 seconds looking around. And he did not come back and say, yeah, you're right. Because he could have asked him that while he was on the stand. And none of that ever happened. Darby said he went down there and looked, and the cell was fine. And all the officers went down there with him afterwards and said the cell was fine. So all that stuff he's doing is just a smoke screen, just like it was for that when he threw himself on the ground because he didn't get a tray. He doesn't get his way. And so he starts just doing anything he can to try to get his way. It's all about Mr. Peoples. Everybody's out to get Mr. Peoples. The appellate court's out to get Mr. Peoples. The judge is out to get Mr. Peoples. I'm out to get Mr. Peoples. I even have some influence with the Supreme Court of the United States and the Court of Criminal Appeals. I don't know where that comes from because I've never even been to the Supreme Court or the Court of Criminal Appeals, but that evidently I have influence there. I've wrongfully indicted him, wrongfully convicted him. He's doing 20 years in prison for something that he shouldn't have done. And he won't even accept responsibility for that, even though he knows he pled guilty to it. And we'll cover that later. But he can't just say things. He can't just come up here and say things because everybody in that whole unit said that he came out with those pins and was flailing them around. They didn't see who he hit. A couple of them didn't see it, but Arliss Anderson saw it. Lieutenant Ford saw it coming at his face, and those pins were there. The wrapping was there. Everything's there that said happened. And you don't have to agree. You need to know that under this law, and you can look at the law. You do not have to agree on whether you think he did it intentionally or knowingly or recklessly. Some of you can think he did it intentionally. Some of you can think he did it knowingly, knowing he might cause injuries. And some of you can think he did it recklessly by the fact that he did it, because all that is an aggravated assault, and it's against a public servant who's doing a lawful duty. That cell was being decommissioned. You've heard them all say it. They have to follow certain standards. They were decommissioning that cell. They had to do some work on it to make it safe for them. And then you get back to, why do you have to do stuff on cells? Because, even introduced it in here, people get out of their cells to attempt to escape. This man did. He introduced it himself. He put his cell, plugged up the cell lock, and walked out and was wandering around like hiding in a trustee uniform, walking around with a blanket where he could get out. All that's the stuff he was introducing. So y'all need to think about this. This man does not tell the truth. He gets up here and lies. He lies to them about the trace. He lies to them about the phone calls. He lies to you about the law. He's just doing anything he can to get his way. Don't give him his way. Don't reward him for being the person that he is. These people that have to protect you while they're watching people in jail, prisons, they have enough to put up with just dealing with the day-to-day stuff and making sure that everybody's safe and everybody gets what they want. But then they have to deal with people like Mr. Peoples. This gentleman over here does nothing but cause them misery, heartache. You heard them. They all have dealt with him. Even Lieutenant Tinker, bless his heart, you can see him trying to be nice and just come on down and get in your cell. And what's he doing? Grabbing the cell, holding on, arguing, and then he starts yelling those words. And I want y'all to remember those words he was yelling from inside that cell. I'm going to kill. Now, I'm not going to repeat the N word that he used.
Why not?
Don't.
That was being yelled out by this man in that cell. Why would you yell that out over a stupid tray that came from Tuesday on a Sunday, and you don't get your Tuesday tray on Sunday? They don't do that. And the lieutenant ended up giving in to him and giving him a tray. It just rewards him. So I'm asking you, when you go back here, you look at this, it's apparent from the injuries on Lieutenant Ford. And I'm not going to harp on them. But you do need to remember why we're here. We're not here because he didn't get to go get his way. We're here that right there is not from a fingernail. This right here is not from a fingernail. Those are sharp instruments coming down, and it didn't come down because he was trying to distract him. He was trying to get him in the eye, guys. He's trying to poke him in the eye, and he missed. That's why it came down here, and it's down here all the way down, because he was swinging. So don't feel sorry for him. You should feel sorry for Lieutenant Ford, who has to go through that every day with this man. Don't reward him for being the way he is. That is not what you do with people who throw fits and try to hurt people in jails that are just trying to make sure everybody's safe. including the people outside the jail. If they're trying to get out, they're trying to harm people in the jail. Do you really think those guys, that this is that important, that all those people would take time out, even people that left? If this man didn't do something that serious, why did they come up here? And Lieutenant Ford, if you want to think he's a liar, wouldn't it have been easier for Lieutenant Ford to say, hey, I saw him stab me in the eye. He was trying to get me. I saw him swing at me several times. Wouldn't that make more sense if he was trying to lie about this instead of I saw his hands coming at me and then I felt pain and I don't know, fingernails or what? Arliss Anderson, who doesn't have anything against him. You didn't hear one thing about Arliss Anderson causing him any problems anywhere else. Comes in here and says, I saw him do it. And then, if you want to know what kind of person he is, just look at all the stuff he even admits to. Throwing stuff on people. Totally causing havoc in that jail. He needs to be put back in prison so they don't have to deal with him. We don't have to deal with him. He needs to go away. But right now, all we need to do first is talk about finding him guilty. Hold him responsible. Don't listen to his wanderings and meanderings. Hold him responsible for what he did that day. Then you can talk about punishment later on. You can adjust it however you think it is. But don't let him just walk away from this. You know what that does? That tells him, you know what? Go do it again. Throw all the fits you want. Do what you want. Then come in here and just go, oh, they're all against me. And everybody just let him go. Go ahead, let him go. If you want him to do this again and just keep on doing this, let him go. Feel sorry for him. Or you can say, you know what, enough's enough. You don't rule this world. You don't get to rule the jail. You don't get to rule this day. And you don't get to rule this court. No matter how hard you try. Hold him responsible. Find him guilty, and then let's get on to the next part, and you can do what you need to do there. Thank you.
All right. Ladies and gentlemen of the jury, this time I'm tendering the jury charge to the bailiff. I'm going to ask you, please step down from the jury, follow the bailiff into the deliberation room. We will await your verdict. By rule of law, only 12 people are allowed in the jury room by law. That means the alternates have to stand out, hold vigil, don't stand up, go outside, relax, stretch your legs. We've had to replace jurors during deliberations before. That's why by law we keep you until the end. But thank you. Be able to pull you into the game here before the end. Thank you for bearing with us. And we are in recess. Thank you.
Sorry.
All right, we have received a verdict in this case. Stand by. Thank you.
No, that's fine.
The record shall show that the state's attorneys are present. The defendant is present. Court has received a message from the jury that the jury has reached a verdict in this case. Please bring the jury out. We will receive the verdict. Thank you. We also need alternates from outside to be brought in. The two alternates. Thank you.
What is going on here?
They're not yet. I guess they're, questions. He said not yet.
Hold on. They don't have a verdict?
I tried to ask him, he keeps telling me, hold on.
Okay.
Maybe some of the restroom or something. Oh,
Yeah.
we'll see.
Let's.
I'm confused because I got about another hour on this video. And we're already to the verdict.
That's what happens sometimes. They go to the restroom. Let's see. Stand by, everybody.
So it wasn't the jury that said, wait a minute, it was Kendall that said. Yes.
And the record shall show that the jury is in the courtroom. All parties are present. And you, sir, are going to be, your name, I'm sorry.
Dallas Stanley.
Okay, stand by. Yeah, you're juror number 28 on this. You are the foreperson of the jury. We have received a message on behalf of the jury that the jury has reached a verdict in this case. Is that true, sir?
Yes, sir.
Is this verdict a unanimous one? That is one that is agreed upon by all members of the jury.
Yes, sir.
Do any of the jurors, fellow jurors, disagree with your foreman's representations? No disagreement is indicated. It does appear to be unanimous. I'm going to ask you pass the documents to the bailiff. I'm going to review for proper form and I will publish the verdict. And in cause number 23, the defendant shall rise, please. In cause number 23, CR 727. We, the jury, find the defendant guilty of the offense of aggravated assault against the public servant as charged in the indictment, signed by the jury foreperson.
Guilty. I don't believe it. Okay, I do.
And this again is 23 CR 727, the state of Texas versus Raymond Peoples. The jury verdict is received. It is made a part of the record for all purposes.
Suck it, loser.
Ladies and gentlemen of the jury, at this time I have received and accepted your verdict finding the defendant guilty of the offense as charged in the indictment. That brings us to a close of phase one of this two-phase trial. We will be proceeding with the punishment phase next. And let me repeat once again, you still are under
See, this confuses me because it's all the punishment phase at Law Talk with Mike.
all instructions previously given to you. Is the state and the defendant ready to move forward with the punishment phase of this trial, state?
Yeah.
And Mr. Peoples?
Yeah.
All right.
Although I do enjoy a good punishment phase.
The state, you have, there is a second paragraph in this indictment, ladies and gentlemen. And at this time, I'm going to ask the state of Texas to read and make a formal statement of this second paragraph of the indictment. Go ahead.
And the grand jurors aforesaid, upon their oaths aforesaid, do further present in and to said court at said term that before the commission of the primary offense, the defendant was finally convicted of the felony of aggravated assault, second degree, on April 22nd, 2021, in cause number 16-24808 in the Criminal District Court of Jefferson County, Texas.
And that is signed by the foreman of the
Yes, sir.
grand jury. Raymond Peoples, you have just heard the reading of paragraph 2 of this indictment, which states that you were finally convicted of aggravated assault on April 22nd, 2021 in this Criminal District Court of Jefferson County, Texas, in cause number 16-24808. Is that allegation true or untrue, sir?
The fact that you have no jurisdiction is not true.
All right. Untrue will be entered into the record on your behalf. All right. The state of Texas.
Yes, sir. We'll need to take a break, get his fingerprinted so we can present the.
All right. We're going to take a break, ladies and gentlemen. Relax, stretch your legs for about 5 minutes, 10 minutes, and we'll bring you back in. And what is the state's prediction for presentation of punishment evidence?
It'll be brief, Judge.
Okay.
They've already heard enough in guilt innocence phase, and then I'm just presenting these.
Okay. All right. Take a break. Thank you, ladies and gentlemen. And we are in short recess.
Yeah.
On the bailiff here.
Yes, he said, hold on.
Weird. Mr. Peoples, you have, this is not a plea bargain case. You have an absolute right to appeal. I've signed the document on that, and the bottom is, the bottom is for you to sign your acknowledgement of the receipt of that, and you will get a copy of that for you and your records.
I would like to give the court notice of arrest of judgment.
That's He's given notice of it and just put it in the record.
Just want to make sure. You know, white people hate my guts or anything else.
Yeah, we want a little bit of warm up.
And everything says.
I don't know how long this is gonna take. Probably use bigger capacity like you need.
Hey, I'm at, that's so big fish in the deal. Which one? Which one? Because he did. Is it the last one?
We need to find folks at Bad Lip Reading to, or insert some absolutely inappropriate dialogue for that conversation.
I didn't know it's just insane. But so the last two, the pink and the orange. Okay, thanks. Okay, here, I'm gonna give Mr. Peoples all three of these copies. And we're gonna only need the top one. He gets all three for whatever purposes he may wish to use those for. The other stays with this.
Mr. Peoples, I don't need to get a fingerprint of your right thumb, and then for the purposes of the prior allegation, when you, on your judgments, for comparison of the judgments. Well, they're not allegations, they were judgments, they're completed and final. I misspoke when I said allegations.
Just make sure that they belong to you.
Put the last name for them.
Peoples.
R-A-Y.
What's the other one? Second.
That's all right.
Yeah.
He's 30.
How much you weigh?
And all the other.
Wait,
Rough as
That's why we have to do that one. I think okay, I see.
brown eyes,
yeah.
black hair, you know, social security number. So there, what's your date of birth?
11/25/88.
Was that all collected afterwards? Yes, because that's a very fair question.
So we don't have to wait for the sentencing for tomorrow or something?
No, we're gonna do this right now. Be your right up on, if you don't mind standing up for me, just go stand right here. We'll get you to, I'll put it a couple times, sometimes it gets a little thick, so just press your thumb down right there. All right, don't press super hard, but just press right there for me. That'll be it. That's all I'll need. I'll get, you send me one. Oh, he's okay. Mr. Peters, I need you to sign right here. This is what it is to take a known print, compare it against the print that's on a judgment to see if it's the same person.
So is it possible to take an unknown print and match it to a known print?
It is.
And what is the process of looking at a print to determine whether or not it's the same?
So all fingerprints are biologically unique. They're every person different fingerprint. No two are alike. They're it's scientifically impossible. So what you do, what we do is you take a fingerprint that you print, you transfer that print to a fingerprint card. You look for certain points, identifiers, and you compare them to the print that is on the judgment to make that identification.
And did I ask you to fingerprint a certain individual today?
You did.
Who did I ask you to fingerprint?
Raymond Peoples.
And do you see Raymond Peoples in the courtroom?
I do. He's wearing a button-down white long sleeve shirt that's rolled up at the sleeve.
Record reflect he's identified the defendant.
Yes, it will.
Let me show you what's been marked as State's Exhibit 41. You recognize this?
Yes.
And what is that?
State's Exhibit 41 is a fingerprint card with, fingerprint and, information of Mr. Peoples.
Okay, and it's Mr. Peoples. What finger is it?
That would be his right thumb.
And why did you just take the right thumbprint?
So on the judgments, they are used, a person will use the right thumb, predominantly most of the time.
And did you have Mr. Peoples sign this?
I did.
And did he sign it?
Yes, he did.
And did you get all
Nigel, we're to the punishment phase. So go through the spanking machine.
his information stating this is his thumbprint?
I did.
Henry States 41.
Any objection, sir?
Yeah, objection.
What's your objection? You just object generally?
What's the point of this?
All right,
I'm not understanding what this is.
you've been to, sir, this has happened before.
Is this
You know,
setup or
he's asking you, do you have any objections to that being admitted in?
This is just a fingerprint to prove up these two judgments that you wouldn't be true to. So I just have to prove them up with the thumbprint. Okay? Yeah.
Thought this was just the aggravated assault. Well, where the other gentleman come from?
You, sir, as you are well aware, once you were convicted in sentencing, the state of Texas is allowed to present proof of other criminal convictions and other information to help the jury make its decision, since a decision on punishment is based on criminal history and the circumstances of the offense.
Oh, y'all.
We're going to this, that
Okay.
the prior criminal history does not come into play until the punishment phase. This is what this is for. Are you objecting to that state's exhibit?
Now that I understand, no.
Okay, then the state's exhibit 41, the fingerprint card of the defendant is admitted.
So let me show you now what's been marked as State's Exhibits 39 and 40. Can you identify those?
Yes, again.
And what are those?
These are judgments.
And are they judgments and convictions of one Raymond Peoples
They,
and are purporting to be?
that's correct.
And did I ask you to compare State's Exhibit 41 with 39 and 40?
You did.
And did you compare those?
I did.
And in your opinion, is States 39 and 40 the same person whose fingerprint is on State's Exhibit 41?
It is.
So is that fingerprint, in your opinion, on both of those judgments, Raymond Peoples' fingerprint?
It is.
This time, Judge, I'd like to tender both certified copies of State's Exhibit 39 and 40. Let's do this. Why don't we identify 39 as, what's the cause number on 39?
39 is cause number 16-24809.
And look at State's Exhibit 40, what is it?
State's Exhibit 40 is cause number 16-24808.
We tender State's 39 and 40, Judge.
Okay,
Have any objections?
no,
Sir? Any objections?
I told him no.
You said no. All right, without objection, state's exhibits 39 and 40 are admitted.
So let's look at State's Exhibit 39. And if you have to, I'll blow it up for you. I'm gonna blow it up pretty good. This is cause number what?
16-24809.
And it's the state of Texas versus who?
Raymond Peoples.
And what is the charge?
Attempt to take a weapon from an officer.
And the offense date?
Was 3/29/16.
And what type of felony is this? What degree is it?
This state jail felony. Mr. Lurk, could you go back one?
Sure.
So 3/19/16. Yes, okay.
So it's a state jail felony, is that correct?
Yes, sir.
And it says this was a plea to a motion to adjudicate. Is that true?
That's correct.
And is that that's a revocation of probation, is that right?
Yes, sir.
And does it say underneath that he pled true to 2 counts under that 3 and 6?
Yes, sir.
And that he pled not true to 7, 8, and 9, is that correct?
Correct.
And what does it say that the confinement was, the punishment was for this?
2 years in state jail division.
And what date up here was this date of this sentence imposed?
4/22 of 2021.
Now, looking back at the indictment, what does it state that he was charged with here, where it says he did then and there do what?
The intention of harming Christopher Brinkmeyer intentionally, knowingly with the force, attempt to take from Christopher Brinkmeyer, a peace officer, the officer's firearm.
So the weapon he attempted to take from the officer was a firearm, is that correct?
That's correct.
And just to make sure we know, on the part of this is, when we do plea papers, do they also have to sign what they call a judicial confession?
They do.
And down here where it says, I have read, can you read what that says?
Yeah, I've read the charging instrument and my attorney has explained to me and I have committed each and every element alleged.
And does it say down here under this that they swear to that?
Yes, I swear that all of the foregoing as well as the testimony I give is the truth, so help me God.
And
Signed
that's it.
by Raymond Peoples.
Okay. So he signed a judicial confession saying he was guilty of that offense, am I right?
Yes, sir.
Okay. Now let's look at State's Exhibit 40. What cause number is this?
16-24808.
And would that match the cause number in the indictment that I just read, which is cause number 16-24808?
That's correct.
And is it State of Texas versus who?
Raymond Peoples,
And what type of charge is this?
an aggravated assault,
And the date of the offense?
3/29 of 2016.
That the same as the last offense too?
It is
And what degree was it?
second degree felony.
And again, was he a revocation of probation?
He was.
And did he plead true to 2 counts, 3 and 6?
Correct.
And that counts being, those counts would be violations of his probation, correct?
That is correct.
And then he also pled not true to 7, 8, and 9, is that correct?
That's correct.
And what was the sentence that the court gave him?
It was 20 years in the Institute Division of TDCJ.
So that's 20 years prison, is that correct?
That's correct.
And was there also a deadly weapon of a firearm?
Yes.
And up here, what was the date of that sentence imposed?
4/22 of 2021.
Now, both of those being on the same date, both of those would have run concurrently or together, is that correct?
That's correct.
And both of them, he was placed on probation, and both of them, he was revoked, is that correct?
That is correct.
I'll pass the witness, Judge.
I got your name, but
Troy Robinson.
sure, Mr. Robinson. So the day, did you recognize?
Those 3 words right there, that's in the middle of the screen. Do you know, can you read, I'm reading it a lot. Judgment adjudicating guilt. Do you know what that means? Judgment adjudicating guilt.
Yes, you're guilty.
Now, deferred, when they say deferred, right? He don't have that paper. But if you put the word deferred right there, what would it be?
To be deferred.
Well, like, what do that word?
If, I guess in a situation, hypothetically, if you were put on deferred probation and you completed your probation without violating it, the sentence will be deferred and you wouldn't be considered guilty of it.
So, in other words, the day that I signed and agreed to this, right? Deferred adjudication, probation, right? It's probation that he's saying, I pled true. You see how you pointed to this and said I pled true? Those counts was because I was on probation, correct?
That would be correct.
So,
I'm not sure what for, but
right, attempt to take weapon from her. But the thing about it is, the fact that I was on probation and if they said deferred adjudicated probation, right, that would mean a delayed judgment, correct?
I can see what you're saying, but I'm not familiar with the facts of these cases, so
Well, I'm not
I don't know
asking,
your history other than what I've been presented.
well, I'm not exactly asking about the fact.
Well, I'm not an attorney either.
Oh, okay, so there we go. So just for a little education, deferred means delayed, right? Adjudication means judge, pronouncing a judgment, right? Probation, well, we know what probation means. So which means the day I sign for probation on a probation like this, deferred adjudicate, which means I wasn't found guilty that day. You ever heard of that kind of?
I mean, you're asking me or you're telling me?
I'm asking, have you ever heard of if a person signed for deferred adjudicated probation that and the judge agreed and announced it, right? Do you remember? I mean, have you ever heard of it not being a judgment until that person is violated?
That's a little bit out of my wheelhouse. I was, the whole dynamics of that.
So how do you understand?
I'm familiar with judgments, reading them, going over what the person was convicted of, and processing the print from the person you compare it to the person.
But you don't understand the difference in the kind of judgments. You just know it's a
Well,
judgment.
no, I mean, I understand what they're asking,
You do?
but I mean, I'm not sure what question you want me to answer.
Do you know what deferred adjudicated probation is?
Yes. I
So-
explained that a second ago.
Right, that's why I'm not understanding why you said you don't understand.
Well, I'm not sure what question you're asking. You had like a 4-part question there.
Okay, I signed, the day I signed that you said, he just showed you my signature,
Correct.
signed for, and the day the judge agreed to, right? And
Okay.
established that I signed,
It's no longer deferred at that point. So
it's not.
No.
So what do,
you were convicted of it.
I was convicted that day.
Correct. The date that's on there, I think it's, I'd have to see the judgment, but I think it's on the right-hand side. It's for, no,
Yeah, look the other way.
other way.
Other way, oh yeah, right here.
No, right-hand side. Oh, yeah. Date of sentence, 4/22 of 2021.
So that was the day I was sentenced, right? Judge, that was the day of judgment, right?
Yes.
Do you, that paper that you just had on my signature, where is it?
Sit there. You see, it's
That was it? That's the same
part of the
part?
exhibit. Towards the back. You see it?
Yeah, of course. Oh, there it is. So. This is. Oh, yeah, we just. Yeah, we just don't, make it simple. Like this, right? So my signature is on this paper. Do you know what that means right there?
Your signature's on that paper?
Right, like this is the start. The fact of, do you know what it means for this sentence to have that date?
Yeah, that's the original, community service, supervision order. The
Right,
day you were placed on probation.
that was the day I signed, right?
For probation, correct?
Right. So if the day that I was judged is right here, and the day that I signed is different, how was I found guilty on the day that I signed?
So what you have here is you're just, showing us one piece of paper. The whole packet, which you guys will be able to look through, is considered, like, it's a court packet, right? It's gonna be a certified copy from the district clerk's office. It's kept in their regular course of business. We get the certified copy, which is gonna have all the information in it, along with his fingerprint, that, the attorney's ready to use. So, I mean, there's several more pieces of paper there's probably like 10 or 12 pieces there for that one package that will explain all of it.
We don't, Shoot both of those and submit you interviews with us. Perfect. So, when I asked you earlier, you said the day that I signed was the day I was found guilty, correct?
I would need to see the piece of paper you're talking about.
No, earlier when I asked you, you said the day that I signed, that I played guilty was the day I was found guilty, correct?
So I wasn't here for your signature. In regular court, what would happen is when they sign for their, like for instance, 4/22/21, is when he was convicted, he would have to sign, give his fingerprint to the clerk, and it would go from that, and the conviction would be filed over at the district clerk's office. Which is pretty much the same thing, if I'm not mistaken, that they do for when they're put on probation. They would receive probation with the judge, they would go next to the clerk, they would signature, fingerprint, and they would go on.
So are you explaining that I signed something April 27th, 2021?
I wasn't here for you to sign it, but in the document, you have your signatures there.
But that's absolutely not true. When the judge found me guilty, I walked out this courtroom without signing nothing at all that day.
I would have to defer to the attorney or the judge on that, I wasn't here for that.
Is that correct, Mr. Lynn?
What, you didn't sign for anything?
Did I sign something that day?
I don't think you signed anything that day, it doesn't matter.
No. Well, it absolutely mattered because you said you understood this, correct?
I do understand.
And you did earlier, when I asked you the day that I signed, was that the day I was found guilty?
And I said this, I would have to see the piece of paper.
So you didn't say that, yes, that was the day he was found guilty. You didn't say that.
Okay,
I'm asking, did you say it?
I would have to have it very back.
No, I'm talking about, or you forgot?
You've asked me a lot of questions.
Yeah, call him for fingerprints and to compare it to the judgment. I just had him read off the judgment. If he wants you to read off of it instead of explaining it, I don't have any objections. Otherwise, he's gonna keep asking the same question, get the same
No,
answer.
I'm trying to get him
I object
question.
to this being outside of this witness's expertise.
I'm trying to get him to answer the question from his understanding.
He can answer if he's able to, under what part he played in the review of these items.
Right, that's why I'm asking you, earlier when I was asking you, do you remember saying that the day that I signed is the day I was found guilty?
So that judgment was completed on 4/22/21, correct?
Yes.
Okay. That paperwork was filed for that date. And all the information in there is certified for that date of sentence commuted. So I was not here for your signature. I did not see you sign it. Until it's in the packet.
But do you understand my question?
What is your question?
Earlier when I first asked you, the day that I signed for probation, is that the day I was found guilty? And you said, yes, that is the day you was found guilty. Do you, I'm asking you.
You're asking it that way.
Judge, the state of Texas will stipulate that the day he signed for probation was deferred probation and he was not found guilty at that time. He was found guilty on April 22nd, 2021.
That's the law.
All right, now I'm getting somewhere, which means that I wasn't found guilty on the day I signed for probation. So why did you go through all of this and present it as if I was found guilty under my signature?
Are you questioning him?
Actually,
No, you're questioning this witness, not Mr. Laird.
Oh, okay, right. So
Come on.
why is it y'all went through all of this as if I was? You just can't fingerprint me, and you trying to add. And you said you compared it to the day I was found guilty, right? And you, because I guess y'all doing it because I said, I don't agree to the priors and all of that. I'm assuming that's why y'all went through all this.
On paragraph 2, the aggravated assault conviction on April 22nd, 2021 is alleged in paragraph 2 of the indictment, which comes into play for sentencing purposes. We read that. I read it. You pleaded untrue.
Right.
Then the state, to prove that up, did what they had to present evidence that you were placed on probation at one time, and then that probation was deferred or unadjudicated probation. It was revoked, and the court sentenced you subsequently on that date. And that's to prove up what is alleged in paragraph 2.
Right. So I said the judgment is not true or whatnot. And you said it is true because I signed it on that date, right?
What's your question?
What is the point of it?
This is a,
I'm gonna object.
Yeah, sustained. That's
Yeah, I am.
the jury is listening to the evidence, and they'll decide how much weight and credibility
Okay,
to give to it.
I'm gonna move
You
on.
don't make an editorial comment, just ask questions. So, but under the rules of law, when somebody is placed on deferred or unadjudicated probation, that is a kind of a newer type of law that came into effect, which is a good thing. The old traditional probation, you were found guilty, sentenced, and your confinement was suspended, but you were convicted. And so a conviction has its difficulties on people. So subsequent to that, the legislature came up with what's called deferred or unadjudicated probation. A jury cannot give deferred probation. They can only give regular probation. But if a defendant pleads guilty to the court, then if it's agreed upon by the parties, then the court can defer any finding of guilt. And they're put on terms of probation which are similar to regular probation terms. Don't commit crimes, and there's 34, 35 conditions, and most of all those conditions are the same conditions you and I have to do every day. But if on deferred probation, they're not found guilty unless during the course of probation, they commit violations of their probation, then a motion to revoke probation can be filed by the state of Texas. And then that is heard by the court. If the court finds by a preponderance of the evidence or greater, which is the same test in a civil court on a motion to revoke probation, it's less than beyond a reasonable doubt. If a court deems that it's been proven while on probation, they failed to follow the terms of probation, then the court can revoke probation and sentence them to the full range of punishment that they were subject to. They, at that point, are found guilty and sentenced. And that is the way a deferred or unadjudicated probation works from beginning through the process. If a motion to revoke probation is filed and then it's revoked and sentenced. This court's, I'm just going to, editorial opinion, 93% of my probationers are successful. The average is about 75% for the country, and we have a 93% success rate in this county. So I'm very proud of our probation office in the way they handle probationers and escorting them through probation. But that's the way generally a probation works when we have what's called deferred or unadjudicated probation. Okay, go forward.
I'm sorry for the broad question. I'm gonna make it, I'm gonna ask you a more substantial question. A second ago, District Attorney Mike Laird confirmed that was my signature. And you confirmed to him that was my signature, correct?
on which document?
On this document that we're looking at.
What state exhibit is that?
States Exhibit 39.
Do you need to see it?
Yes, I would like
Yeah,
to.
I'm going to ask the bailiff. Hold on. Let the bailiff, if you'd be so kind, pass that document to the witness so he can review. Thank you, sir.
Questions?
did you confirm with the state that that was my signature on that document?
Yes, on State's Exhibit 39, clause number 16-24809, on the very last page, in which I read earlier, speaking with Mr. Blair, is your signature along with your thumbprint at the bottom that I use for comparison.
Was that to prove the judgment of that document?
There's actually more than one fingerprint on this. Used every fingerprint that is here. There's also a fingerprint on page 4. Page 4 of this document as well. And so both fingerprints were compared, and they compared to your fingerprint on State's Exhibit 41.
What was that to prove? What was it to prove that that judgment on that document?
That was to prove that the same person on the fingerprint card, you rang the Peoples, is the same person who put their fingerprint on this judgment.
That's
State's
all.
Exhibit 39.
That's
That's
all.
it.
That's all.
Yes, sir.
Okay. No further questions?
Anything else?
No,
Is this man excused?
please, Joe.
You are excused.
And Joe.
Next, please.
Good rest, Joe.
State rest. Mr. Peoples, anything you want to present for punishment purposes?
Yeah.
Can you think of anything you'd like to present to the jury to help them? Because on the punishment, it's about character. Did you want to make a summary of what you want to tell them about you?
No.
Okay. No. Ladies and gentlemen,
That's the best thing he did all day. I mean, he closed strong. Too bad he ran his mouth for the past 5 hours.
parties have rested. I have a proposed jury charge that I need to review with the parties and then read for sentencing. It's 4:45. I'm gonna do what y'all want. Would y'all like to break for the evening and then come back tomorrow and deal with? No? Yes? Oh, boy. We've got, well, here's,
Get her done.
I know you'd like to move forward, but it's going to take, the parties get to review it, and if there are any changes, I've got to make the changes. It's going to take probably 15 minutes or so for everybody to look at it, depending upon how fast they want to read through this. And then if there's no objections, then I can read the jury charge and y'all can go and deliberate. If there are some changes, y'all got to bear with me to make the changes. What do you want to do? I'm going to do what the jury wishes. It looked like we had about a half on one side, half on the other. Does anybody, let me ask you this, does somebody have a time problem that you need to get to this evening that you just can't stay a little later? If you do, let me know, because you do, ma'am? All right, well, that carries with everybody. If it's just one, and that's okay. Yeah, but no, but an alternate, I've changed alternate, I've included alternates during deliberations. We've lost yours during deliberations, sir. That's the way it is. It's just.
Oh my God, I would be so pissed if I was on that jury and somebody wanted to come back the next day. Oh my God, just stay there and finish it.
The way they have to be present to listen to the arguments and to make a decision. And it is the court's decision on the timing. Ladies and gentlemen, if one person can't make it.
Please don't make me.
No, I'm sorry, you don't run things, sir. If one is released, there's always a chance we could have a problem. That if two people couldn't serve out for some reason, and it has happened, then without the alternates, then we are mistried, and that's not going to happen. The mistrial means you have to start all over again. We don't want that. I'm going to ask you to return back at 9:30. Please remember the instructions the court has given to you, and this, it's people generally.
People do not want to do it. I don't want to do it.
I'm sorry, but people, we work generally until 5, but when there's a problem, all the jurors have to be available, and so, and it's a regular work hour until 5, so. Are you sure? Okay, y'all want to stay and get this accomplished? Is anybody else? Okay, it looks like everybody's with us. All right, we're going to take a short break while they look at it for a few minutes, and if it's fine, I'll read the charge, then you'll go and deliberate, okay? All right, thank you, ma'am, for working with us. All right. All right, we're in short recess. All right, we now recall cause number 23, CR 727, the state of Texas versus Raymond Peoples. The defendant is present, the state's representatives are present. Have the parties had an opportunity to review the jury charge here for this punishment phase? And are there any corrections or changes to it? First, state.
Nothing for the state, Judge.
And Mr. Peoples, any changes?
I don't care about what y'all doing. Just get it over with.
All right, bring the jury in then. All right, the record shall show that the jury is seated in the courtroom. Ladies and gentlemen of the jury, at this time, I'm going to read to you the jury charge for the punishment phase of this trial. And again, please continue to observe the instructions previously given to you. As before, this charge will be left with the jury and your foreperson, so you can refer to as necessary during your deliberations. Members of the jury, you have found the defendant guilty of the offense of aggravated assault against public servant as alleged in paragraph 1 of the indictment. Paragraph 2 of the indictment further alleges that the defendant was previously convicted on or about April 22nd, 2021 in cause number 16-24808 for the offense of aggravated assault in the Criminal District Court of Jefferson County, Texas, and that this conviction had become final prior to the commission of the offense for which you have now found him guilty as indicted, the first-degree felony of aggravated assault against public servant. To this allegation in paragraph 2, the defendant has entered a plea of untrue. It now becomes your duty to determine if these allegations are true or untrue, and to set the punishment in accordance with the law. If you believe from the evidence beyond a reasonable doubt that the allegation in paragraph 2 is true, you should so state in your verdict and assess punishment for the commission of an enhanced first-degree felony. If you do not so believe, or if you have a reasonable doubt thereof, you should find the allegation in paragraph 2 untrue, and so state in your verdict, and thus assess punishment for the commission of a first-degree felony. First-degree felony punishment. Our law provides that an individual judged guilty of a first-degree felony shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice, in other words, prison, for life, or any term of years not more than 99 years or less than 5 years. In addition to imprisonment, an individual judged guilty of a felony of the first degree may be punished by a fine not to exceed $10,000. Enhanced first-degree felony punishment. Again, this would apply if you deemed that the prior conviction was proven true to your satisfaction. Our law provides that an individual judged guilty of a first-degree felony who has previously been convicted of a felony, and this would be a felony above a state jail felony, shall be punished by confinement in the institutional division of the Texas Department of Criminal Justice prison for life, or for any term of years not more than 99 years or less than 15 years. In addition to imprisonment, an individual judged guilty of an enhanced first-degree felony may be punished by a fine not to exceed $10,000. You see the difference between these two? If it is not enhanced by a prior conviction, it's 5 to 99 or life with a fine. If it is, it's 15 to 99 or life for imprisonment, and then $10,000, up to $10,000 in fine. good time credit, and parole.
You can be mom.
Under the law applicable in these cases, the defendant, if sentenced to a term of imprisonment, may earn time off the period of incarceration imposed through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignment, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time earned by the prisoner. It is also possible that the length of time for which the defendant will be in prison might be reduced by the award of parole. Under the law applicable in these cases, if the defendant is sentenced to a term of imprisonment, he will not become eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less,
Mary Smith.
without any consideration of any good conduct time he may earn. If the defendant is sentenced to a term, and this is not going to apply in this, but it's the law and we've got to go through with it. If the defendant is sentenced to a term of less than 4 years, he must serve at least 2 years before he is eligible for parole. And once again, that is not applicable under this set of circumstances because the minimum is higher than 4 years. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time might be applied to the defendant if he's sentenced to a term of imprisonment, because the application of these laws will depend upon decisions made by prison and parole authorities. Now, you may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. And you are not to consider the manner in which the parole law may be applied to this particular defendant. Of course, that's because those decisions are made by other authorities. General instructions. The attached verdict forms are supplied for your use. When you have reached your verdict, your foreperson should fill in the appropriate form and sign their name as foreperson. In arriving at your verdict, it is not proper to fix the punishment you assess by any system of averaging. Your verdict must be determined only by a full, fair, and free exercise of the opinions of each juror based upon the evidence presented. Your verdict, as before, must be unanimous. Your failure to follow the law contained in this charge could result in a mistrial being declared, and your deliberate violation of these instructions could result in your being held in contempt of court. Okay. We have two sets of jury instructions, and each of them have 4 hours.
I don't know what's going on here.
Review and determine which is applicable based upon your decision on the prior conviction, whether that's been proved or not. The first set, and this is,
For the record, I did not touch anything. Right here. Hand check.
is if you believe that the prior conviction has been proven. First option is we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment, and assess his punishment at confinement in the institutional division of the Texas Department of Criminal Justice. I will refer to that as prison from here on, for a term of blank years. And that would be no less than 15 nor more than 99, a place for the foreperson to sign. The second option of this bundle of 4, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense, that is something above a state jail, 3rd or higher, as alleged in the indictment, and assess his punishment at confinement in prison for a term of years no less than 15, no more than 99. In addition to such imprisonment, we assess a term of blank dollars not to exceed $10,000. Third option, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment and assess his punishment at confinement in prison for life. And the final fourth option, we, the jury, find that prior to the commission of the offense for which we have found the defendant guilty, the defendant was previously convicted of a non-state jail felony offense as alleged in the indictment and assess his punishment at confinement in prison for life. In addition to such imprisonment, we assess a fine of up to $10,000. Only one option of the four on either set can be signed. Does everybody understand? Everybody understand your four options here? And the next set are based upon whether, if you believe that the state has not proven beyond a reasonable doubt that the defendant was previously convicted.
They have.
Sir, you just made an outburst. Again, an inappropriate outburst. Please don't do that again, sir. Thank you. These four, again, we will go over them, ladies and gentlemen. The first option of these four, we, the jury, find the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for a term of blank years, no less than 5, no more than 99. Does everybody understand the distinction here? Place for the foreperson to sign. Second option, we, the jury, find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for a term of blank years, no less than 5, no more than 99. In addition to such imprisonment, we assess a fine of not to exceed $10,000. Everybody sees the difference there. A fine is applied on this one if that's your choice. The third option, we, the jury, find that the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for life. And your final option, we, the jury, find the defendant has not been convicted of any previous felony offenses as alleged in the indictment and assess his punishment at confinement in prison for life. In addition to such imprisonment, we assess a fine of blank $9. Only one verdict form can be signed out of these 8. Does everybody understand the distinctions? All right. As before, the state of Texas may open and close final arguments. What says the state?
Once again, Judge will waive a right to open reserve right.
You may. Mr. Keeples, you may present your argument to the jury.
Wait, my wife.
All right. You're doing that voluntarily and because that's what you want.
That's what I want.
Oh, then the state may go forward.
I'll be brief since we don't have, we're after hours here. I think it's pretty obvious when you look, and you can even take these back with you if you want to. The allegation alleged in the indictment states he did it number 40. You need to look at it, which is the actual assault, which was the actual conviction occurred before he committed this offense and was convicted of it. So makes it 15 to life, and that's what we're asking you for. And I think you need to, I feel really bad because whatever I ask you to do, I want to put you back. I'm going to put him back with those jailers. They have to put up with him. But he talks about the fact that, well, first of all, he says he does so well in prison that that's where he doesn't commit any other of these offenses. That he says he does well and he's out in free population. So you're actually doing him a favor of getting him out of isolation and putting him in prison. And I hate to say that, but because it is punishment. And I'm asking you this because I want you to think about this. First of all, he's right. He was placed on probation, I'll just do it this way. He was placed on probation. If you look at this, you'll see that back here on the signatures is not only the Raymond Peoples signature, but my signature. I gave him a chance. Back in 2016, I gave him a chance. I said, if you'll own up to this and you behave yourself, you can get out of this without a conviction. You get probation for 10 years. And if you're really good, you can get off probation without a conviction. He couldn't follow the rules. And that seems to be a pattern with Mr. Peoples. He doesn't want to follow rules. He wants to control everybody. That's what he wants to do.
Because you said.
Sir,
He wants to
sir,
control
you-
everybody.
I'm sorry, hold
So,
Sir, you cannot make outbursts. You gave up your opportunity to make a final argument. He has a right under the law without interruption to make his final argument. So please follow the rules, sir. Go ahead.
he cannot follow rules. And the problem is with this is that it's kind of funny when he does it in here. But when he does it in a jail setting where there's weapons or he's got things that he can hurt people with, or where he throws species on them or does things to them to just totally make everybody's life miserable. Plus he's got other inmates that he's throwing things on. He's trying to escape. He's doing all these different things. It's not funny. This time it's not so funny as because he's facing 15 to life and it's serious. And yet he's still here making all these comments because to him, it's just a game. Everything is a game. It's not about anything but people. It's all about his people. So what I'm going to ask you to do is I'm going to ask you to make this sting because he was serving a 20-year sentence when he did this, and evidently that doesn't scare him one little bit to serve a 20-year sentence. He's asked you a while ago, he told you just go ahead and give me life to send me home, and that's up to you. But I'm asking.
That's what it is. I'm telling
I'm sorry,
Jerry, I'm arrested.
sir. The second time I've had to scold you on making outbursts during a time that he is not to be interrupted by law, just like you were not to be interrupted if you wanted to make your closing argument. Please follow the rules. Again, I state to you, please follow the rules.
And it makes me sad that an individual can't just do what he's asked to do. I mean, it's real simple. Just move here, do this, just remain quiet, follow the rules. But he has to be in control. And we talked about that in board hour. People have to be in control, and you know he's got to be in control being his own lawyer. He tried to be in control in this courtroom by stopping and saying, and I let him have his free reign. Y'all saw that I did that. When he got up there and said, I let him have his say. And I wanted him to have his say. I wanted him to be able to tell you everything he wanted to tell you because you realize who he is.
Because you had already.
Sir, this is the third time during the final argument you have interrupted the attorney. And again, do not do that.
So y'all go back there. You know that enhancement's been proven. So following your oath, you find it true. And the first 4 pages that you see up there, verdicts, is what you're going to be looking. And you're going to ask me to give you something. I'm just going to ask you to give him a really good bump up from 20 years because of the fact that he was serving 20 when he did this. And that doesn't seem to affect him. So he needs to get a little spanked a little bit harder to make sure that he understands that he's not in control.
Pointing the gun is
He is
Sure.
not in control.
For the record, that's the 4th time that the defendant has defied the court's order and has interrupted the prosecution who is giving his final closing, which the law says he can do without interruptions, unless you want to make a legal objection.
That was a legal objection.
That was not, sir.
Objection. For pointing the gun,
Proceed.
30 years to life.
Sir, your objection's overruled. Proceed.
See, the problem is you wake up every morning and you see violence out on the street. And so what do? We put them in jail. And we trust them to people that they come up here and they try to do their best to watch these people. And what does he do? He creates the violence in the jail. You can't seem to stop him from doing that. So there's only one place to go, and that is someplace where he's going to be controlled by some state people that will have more resources than our county jail to keep him there, to keep him under control. So I'm asking you to at least double what he got before, from 20 to 40, to make sure he knows that this is not the right thing to do, to treat people the way he treats people, and he's not in control. So thank you for your time.
And ladies and gentlemen of the jury, at this time, I'm tendering the jury charge to the bailiff. I ask you to please follow your 4-person into the jury deliberation room. We will await your verdict. And alternates, thank you for hanging in there with us.
If y'all feed up this man sleep at night, and get life in prison.
Sir, you're going to have to muffle him. He can't be speaking to the jury as they're leaving like that. That's improper. Please note that was the fifth time the court had to scold the defendant for making outbursts at closing during the state's closing. That is all. We're in recess. We're in recess.
What else can you do wrong? What else can you hurt? How else can you hurt? Do it? Keep me in isolation for another 12 months? Okay. Oh. Congratulations, Mr. Laird.
Problems is that you can help him with this, but the court order that we have in place is he's not supposed to have any contact with you. And I'm willing to change that, but nobody's asked me. And that means that people are changing the rules. And I'm the rule maker on probation, on my probationers. Y'all are going behind the scenes and doing things you shouldn't be doing. And here we are, I'm listening to them, and everybody's getting in trouble here. The more I hear, everybody's getting in trouble. It's one bad thing after another I'm listening to, and I haven't approved the behavior that's resulting in these acts I'm listening to. I mean, you got to follow the rules first. That's the way the law is. Those are laws. What was it about disagreements with his mother?
Yes.
What do you mean?
He would tell me they just didn't get along sometimes. And then he was staying with his girlfriend. It wasn't anything big in particular, but he said he just had a lot going on with family life.
Really? Well, that's odd. He's not supposed to have any contact with his mother. She's the victim of this crime that he assaulted her. That's why he's on probation. He assaulted that lady. He's not supposed to have any contact unless I approve it. He's been contacting, dealing with. You're kidding me?
I haven't been staying with him.
No. He says you've been associating with her.
Oh, no, you didn't.
I'd allow it under circumstances, but she's the victim. You assaulted your mother. God bless you. Who does that on this planet? You're convicted of assaulting your own mother. And you can't have any contact with a victim. That's in your probation order unless I approve it. Shame on you. Anything else? It's just what happens in these hearings. I find out information that I probably should have been known about. Because I'm supervising. And apparently the rules don't apply, especially my order. Sure, he has he has shown bizarre behavior, and he's being held accountable for bizarre behavior. But nothing shows in the record that the defendant was unable to conform his conduct to lawful behavior because of some medical reason. Thus, he is held accountable just like all of us. Shame on you for your actions, especially going in and committing a terrible offense of pulling your pants down and waving your penis to neighbors. Shame on you for that. We've had situations in this court where people pull out a gun and shoot the person in the head for that and shoot them somewhere else for good measure. But nonetheless, you're presumed sane and presumed competent unless otherwise shown. That means you have to follow the rules like all of us, sir.
You're going to ask me to give you something. I'm just going to ask you to give him a really good bump up from 20 years because of the fact that he was serving 20 when he did this. And that doesn't seem to affect him. So he needs to get a little spanked a little bit harder to make sure that he understands that he's not in control. He is not in control.
For the record, that's the fourth time that the defendant has defied the court's order and has interrupted the prosecution who is giving his final closing, which the law says he can do without interruptions, unless you want to make a legal objection.
That was a legal objection.
That was not, sir.
Objection. For pointing the gun,
Proceed.
30 years to life.
Sir, your objection's overruled. Proceed.
See, the problem is you wake up every morning and you see violence out on the street. And so what do? We put them in jail. And we trust them to people that they come up here and they try to do their best to watch these people. And what does he do? He creates the violence in the jail. You can't seem to stop him from doing that. So there's only one place to go, and that is someplace where he's going to be controlled by some state people that will have more resources than our county jail to keep him there, to keep him under control. So I'm asking you to at least double what he got before, from 20 to 40, to make sure he knows that this is not the right thing to do.
Okay, I thought that we don't get it. Do we already get to the end of this thing? I went to the clip. I thought I had a little left.
To treat people the way he treats people, and he's not in control. So thank you for your time.
And ladies and gentlemen of the jury, this time, I'm tendering the jury charge to the bailiff. I ask you to please follow your foreperson into the jury deliberation room. We will await your verdict. And alternates, thank you for hanging in there with us.
And y'all feed up the man sleep at night. And get life in prison.
Sir, you're going to have to muffle him. He can't be speaking to the jury as they're leaving like that. That's that's improper. Please note that was the 5th time the court had to scold the defendant for making outbursts at closing during the state's
We got a guilty verdict. I mean, we just didn't get the penalty phase,
closing.
the punishment phase.
That is all. We're in recess. We're in recess.
What else can you do wrong?
Punishment phase.
What else can you hear? I else can you hear to do it? Keep your isolation for another 12 months?
Anybody who feels left out, they can come on over. Just come on over to Chicago, and I'll administer the punishment phase for you.
Congratulations, Mr. Mayor.
Well, clearly this is Brecken's fault. Okay. I was trolling you. I thought we had a verdict. And we did. He's guilty. But of course, it's perfect. I had to leave you unsatisfied. I can't have it any other way. I have a long record of leaving people hanging. Thanks for coming out. I'll see y'all soon.